I'm
Yeah,
going
you
to
can get.
turn it over right now. Jerry, we're live, so we have about over 100 people in right now. So,
No,
Jerry, I'm going to
wonderful.
turn it over to you to make our introductions and to introduce our speaker for the course today. So, Jerry, take it away, sir.
All right. Well, welcome everybody, and thank you for the privilege of your time. We are grateful to be able to spend this time with you and help you get that HOA board certification. Without further ado, Alan, just well, let's get started.
All right. Well, that was a fantastic introduction. I wish Jeff would be that quick. Uh, my
We got.
name
Well, since you said that, I'm going to take up a second. Just
See, there you go.
not so much spite, but I really did forget something. We will place the evaluation link into the chat a little bit later on as we near the end of the webinar. The evaluation link, you'll click on it. It takes you to a quick evaluation, and then the submission page, the confirmation page will form your certificate that you can print instantly. But I'll go over that again a little bit later as folks are still populating. So, Alan, now I'm done.
All right, perfect. So thank you both for the introductions. My name is Alan Schwartzseid. I am the managing partner of the Orlando office of Kaye Rembaum. We've got 22 attorneys, 4 offices between here and Orlando. We've also got Pompano Beach, Palm Beach Gardens, Miami by appointment, and in Tampa. So anything that your community needs, I've personally got clientele between Perry, Florida, and Miami Beach. Anywhere you're located, if you are a community association in need of legal services, we are here to help. And we do work with Associa. They do a fantastic job, and they're here to help as well. So bottom line, we've got way too much material to cover for me to waste time talking about our firm. I'll throw in some tidbits here and there, but as Jerry mentioned, let's just go ahead and get started with the HOA board certification class. So your first question that you want to answer when you're talking about board certification, why the heck are we here? Why are you taking this class? Well, you've got 2 options in order to comply with Florida law as a new director in an HOA. One is you can take a class like this, get the certificate that Jeff mentioned, and provide that to your secretary, or if you're managed, to your manager. And that takes care of certain requirements that you have under Florida law. Within 90 days after you're elected, or up to a year before you're elected, you have to either do that, which in my opinion is the best and right way to do it, or you've got to sign a piece of paper that says, I've read and will uphold what's in the governing documents of the association. And it used to say, I understand, or something to that of that nature. And then it became very clear that no one was actually reading these documents. And even those people that did read them didn't understand them, because unless an attorney like me or our firm has cleaned them up a little bit by amending them, they're probably entirely unclear. They conflict internally. And frankly, 90% of the time, they don't even make sense to me. And I've been in this industry for 13 years. So the bottom line is the people that are on the call, and yes, I'm preaching to the choir a little bit, but you guys are doing the right thing by making sure that you go through this class and learn a little bit about what it means to be a director and how to do things the right way versus just signing a piece of paper that in reality means absolutely nothing and doesn't benefit your community. If a director can't give up 2.5 hours of their time at the onset of being a director, my opinion is that's not someone who should serve as a director, because they probably don't care enough to really contribute to the community, which is, by the way, the goal of being a director, is to make sure that the community runs smoothly. Moving forward, a director who doesn't do this and either take the class and provide the certificate, or provide that signed piece of paper that says, I've read the documents, etc., within 90 days after they are elected, is off the board temporarily. They are suspended. They're not removed altogether. They're suspended from service automatically and without a vote of the board until they complete that requirement. The certification doesn't have to be done again, so you don't have to take this class again or sign the piece of paper again until that director steps off the board. So I mentioned a suspension a minute ago, which is if you don't have this certificate within the amount of time that's required, that 90 days. There's a big difference between a suspension from service, which is temporary, and actually being interrupted, being removed from office, or coming off of the board by resignation, or one of the other reasons we'll get into later on during this presentation. So if your service is interrupted, meaning you're actually off the board, just understand you got to take this class again. Now, Also understand a lot of attorneys teach this class very differently. There are people that are not attorneys that teach this class and teach it differently. It's all based on the individual's experience. And so the thing that I want everyone to understand is there's nothing that says you can't take 5 of these classes to really understand what you're supposed to do. There's nothing that says you can't take it, including with me, once a year or once a month, whenever I teach it. You can take it as often as you want and get as much information out of that as you can. Many people do that, to be candid, to not pay attorney's fees. They use the Q&A during classes like this to ask some of the questions that they would have asked their attorney. So there's nothing that says you can't do this multiple times or that you shouldn't do it multiple times, but you only have to do it once unless you come off the board. Now, the association needs to keep the certificate for 5 years after the director is elected or appointed, regardless of how long they serve. Now, when I say regardless of how long they serve, if they're off the board 6 months later, you still keep the certificate. If they're off the board 7 years later, hopefully you've kept that certificate so that you can show during that entire 7 years that the board member actually complied with this requirement. Not having that written certification or the educational certificate that you'll get after today's class doesn't affect the validity of anything that director voted on as a director. So just understand, yes, it will mean they're off the board, but if the board wasn't aware of the requirement, you should have taken this class. But if the board wasn't aware the director didn't comply with that requirement, anything that the board decided while that non-compliance was going on, when they technically were suspended, that vote that they put in still counts. That doesn't mean, by the way, to let this slide. Make sure that they do at least the bare minimum. Moving on, chapter 720, and we'll talk about a lot of the stuff that's in these slides later, but I like to at least go through a very basic explanation of why an HOA and a condo are different.
Alan, can you put the slides up? We can't see them.
Oh, you know what? I thought they've been up this whole time. Thank you for pointing that out. I will do that right now. See, leave it to Jerry to save the day. I appreciate it. All right. Moving on, now that hopefully you can see the slides. And by the way, you didn't miss anything. I've gone through everything that's been in the slides so far. So moving on to some of the distinctions between an HOA and a condo, because a lot of people will cite the condo statutes, but they're talking about an HOA, which means that those statutes don't apply at all. An HOA is basically a creature of contract. Your declaration says almost everything about how your community is supposed to operate. In a condo, it's almost all statutory. Your declaration, your governing documents, they're almost secondary. So I want you to understand the statutes and I literally just reviewed the entire set of statutes within the last 2 weeks for HOAs and condos. You're looking at about, I think it's 70 pages for HOA and another 100, so 175 pages for condo. So an HOA is much less regulated. Most of what you're going to have to go by is going to be in your governing documents, not the statute, but we'll get into that a little later. I'm going to skip some of this. It's really here for your benefit. And as Jeff mentioned, once the class is over and you click through the survey, you will have access to these slides. You don't need to be taking notes on everything I say. So I'm going to skip through some of this just to move along to this one. Which version of Chapter 720 applies? So Chapter 720 is the HOA chapter. It's the statutes that govern your community if you're in the right class today. Contract Law 101 is basically that whatever substantive law was in place when a contract is signed governs that contract. And I need you to understand that your declaration is by law a contract between the members and the association. So the reason that everyone needs to comply with the declaration is because they have a contractual requirement. Now, there are also constitutional due process rights that protect from retroactive application of new laws. Let me put that in plain English for you, okay? If a law changes and it changes your substantive rights, it's going to change your rights, and in turn, you're entitled to the benefit of what was already in your contract. So a law can't say, well, the association, I'll give you a perfect example. My opinion, one of the laws that were passed last year is unconstitutional. Okay, we'll skip ahead to covenant enforcement for a second. There was a law passed last year that says, regardless of what's in your governing documents, you may have had the ability to enforce X, Y, and Z for even the last 50 years. But anything that you can't see from the frontage of the lot and anything you can't see from an adjacent lot, as long as it's something that was installed, maintained, etc., in the backyard, basically, not something you can enforce regardless of what's in your covenants. Well, to me, that's an unconstitutional provision if you are applying it to an existing declaration. That's what we're talking about here. Now, the exception to this is if your declaration, which most HOA declarations do not say, but if it does say that you're incorporating the HOA statutes as amended from time to time, that's magic language. Okay, what that means is every change in the HOA statutes in Chapter 720 will apply to your community regardless of what's in the declaration. So everything in the statute is going to override everything in the declaration in the event of a conflict. Again, most communities don't have that. Okay. Now we also talk about, I mentioned the substantive rights. There's also a difference here between substantive and procedural rights. And by the way, your attorney is going to be the one that's making these decisions. I'm mentioning it primarily so that you guys are aware of this issue. A procedural right is you're changing what notices go out and how they go out for your election meeting. Okay, that's a procedural change. If it's a procedural change, then what I just said about contract and the date of the statutes being applicable, blah, 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 none of that matters. Okay, a procedural change in a statute that conflicts with your governing documents, usually it's going to be your bylaws, will generally override what's in your governing documents. This is why I say reach out to your attorney and your manager fairly frequently to get these opinions rather than just thinking, oh, well, I know how to read the bylaws. They're pretty clear. That might not give you the answer to your legal question as to what you're required to do. Okay, because Florida law is different than, well, here's our documents. You might have to look at both of those two things in conjunction. And frankly, again, I think that should be your attorney, not even your manager looking at it. But you want to reach out to your manager so you know whether it's something that's entirely clear or if it's something that needs to go to counsel for an opinion. The other reason I mentioned getting a legal opinion on most things that are important to an HOA is that if you get that opinion, you are protected by what's called the business judgment rule. We'll get into that later, but it's basically a way of protecting the individual directors in the association and their decision-making as directors. All right, moving on. So we talked about substantive versus procedural. I'm not going to go through this in detail, but just understand there are some examples here of substantive rights. You're welcome to take a look at them later on, but with 188 slides, we're just going to go ahead and move on. Conflicts between 617 and 720. So I talked about 720. This is the HOA statute. When there's a conflict between that statute and another chapter, which is 617, that's the not-for-profit statute, 720 is going to control your community. I need everyone on this meeting to understand something that many people seem to not understand. You are running a business by being on the board of an HOA. A lot of people look at that as, well, we're just volunteers. True, you are volunteers, but you're also running the business. It's a not-for-profit business, but you're running the business of the association. So all of your decision-making needs to be business decisions, not emotional decisions. Making those business decisions is what's really going to protect the individual directors from any potential liability for anything they did as directors. Okay, but bottom line for this slide in particular, any conflicts between the not-for-profit statutes and the HOA statutes are going to control. Again, this is something that presumably your attorney is going to be giving you an opinion on, rather than the board just unilaterally deciding how this plays out. Now, there are regularly conflicts between the declaration, the articles of incorporation, and the bylaws. That's because people hire attorneys that are not specifically HOA condo knowledgeable. They hire real estate attorneys. Well, can you just amend our bylaws? Okay, well, tell me what you want in there and I'll make the change. Great. Okay, they do it procedurally appropriately. But don't even think about the fact that what they put in there is completely the opposite of what it says in the declaration. So when you get these conflicts that come up, and again, this is an attorney issue, but I want you to understand the order of importance here. You're going to look at the old expression, a little dab will do you, okay? Declaration is going to be the bad mamma jamma. This is your top dog document. It is literally, under Florida case law, the constitution of your community. So this is going to be generally harder to change. It's going to usually require a member vote to change it. But basically everything in there is presumed valid unless it's arbitrarily enforced or it's a covenant that you're not allowed to have at all under Florida law. So the courts are going to presume if it's in the declaration, it's valid and it's enforceable. Your next in line document is your articles of incorporation. Okay, by the way, your declaration, for those of you that don't know what I'm talking about, that's what a lot of people refer to as the CC&Rs. Because usually it's called your declaration of covenants, conditions, restrictions, easements, and all the other crap that people throw into that title. Okay, that's basically what we're talking, well, not basically, that is what we're talking about here. When I say declaration throughout the course of the day, that's what we're talking about. Now, back to the articles of incorporation. This is really just going to say, here's the name of the corporation. Here are the current officers of the corporation. Here's what the corporation is being formed to do, which is to run an HOA. The bylaws, most people think these are going to control the day-to-day operation of the community. In reality, they're going to control a lot of the procedures. They're going to control who's a director, who's an officer, what are the officers' duties, how do the elections run, things of that nature. So it's really procedural. Then you've got your rules and regulations. These are usually going to be board made. It might be rules, it might be regulations, it might be architectural criteria, policies and procedures. Any of these documents that are made by the board are going to be given the least credence by a court, and they are last in line when it comes to the order of priority of these 4 types of documents that I've mentioned. So just understand the order of importance, and in the event of a conflict, the order of controlling is first the declaration, the CC&Rs, then your articles of incorporation, then your bylaws, and then all the other stuff that you've got. Now, another thing that I want to point out, make sure, please, that your attorney that you're working with, and if you're not working with one, I strongly suggest you have an attorney on call that's not going to charge you an annual fee or charge you just to be a client or a retainer or anything like that. Just someone that you can reach out to. I'm happy to be that if you don't already have it. But make sure that that attorney, whoever you're working with, has copies of all of these rules and regulations, architectural criteria, and everything else, the resolutions of the board that are pertinent at the time. Because if they don't have those and they're not recorded in the county records, which most people haven't done, they haven't recorded these documents, they have no idea what they're supposed to be enforcing or how. So I strongly suggest you make sure that the attorney you're working with and your manager, almost more importantly, have copies of all of these documents. Moving forward, members' rights and meetings. Annual meeting of the members. The association does actually have to hold a meeting of the members in accordance with the bylaws. The election of directors needs to happen at or in conjunction with that meeting. Now, when I say in conjunction, my perspective is that's not part of the meeting necessarily, okay? The bylaws are generally going to say when and where that meeting is held. So for this entire slide and probably the few after, you're going to look at your bylaws, not any other governing document. Special member meetings, basically every meeting except the annual meeting, when they're held, because the board calls one, or at least 10% of the members, or whatever percentage is in your governing documents, those need to be noticed as well. If you're sending notices, just understand the statutes recently changed so that it is the owner's obligation to notify you when you're sending these notices out. It's the owner's obligation to make sure that the association has up-to-date information regarding their mailing address, and if they're using their email for purposes of you sending out notices as an association, that email address is up to date and capable of receiving mail. It is not the obligation of the association to go chase people down to get up-to-date information. So when someone says, well, you know, I have a mailing address, you sent this to the property. Okay, that's great. It's your burden to tell me what that mailing address is if you want things sent there. By the way, the fact that an address exists on the property appraiser's website or in a deed does not mean that it's been designated for purposes of mailing. That's an argument we get fairly frequently. Well, you could have looked at the deed, or you could have looked at the property appraiser's website. Sorry, but I don't have the obligation to do that. And especially when it comes to certain notices, only the owner of this property is entitled to get it. So if I send it to the wrong address, you're going to come back after me for sending it wrong. So bottom line, you're only obligated to send out notices to the addresses people have provided, and only the last address. Okay. When is a special meeting held? Like I said, when the board calls one, or when at least 10% of the voting interest of the association send you a petition asking for a meeting, unless the governing documents provide a different percentage. Annual member meeting notices and agendas. If the bylaws don't provide for giving notice of member meetings, the association still must mail, deliver, or electronically transmit notices of all of these meetings, whether it's a special meeting or the annual meeting, not less than 14 days prior to the meeting. So understand, this is not a board meeting. We're talking about the members getting to vote on something. That is what a member meeting is. So when someone says, well, the members get to vote at the board meeting, I literally had this come up at a special assessment meeting a few weeks ago. An owner was adamant that, well, why aren't you taking a vote of the members? Because the members didn't get to vote on a special assessment, which is why it was noticed as a board meeting. Okay, just understand that you need to make sure you're providing notice of the right kind of meeting, whether it's member or board. That's an error that I've occasionally seen associations get into. Evidence of that notice must be made by an affidavit that's signed by the person providing the notice that stays in the association records. It needs to be mailed or delivered to the addresses that have been provided for mailing notices, or the email address. Now, keep in mind, in order to use email addresses for purposes of sending these types of notices, each owner needs to actually opt into receiving email notices. If someone has not opted in, and there is a form that we usually prepare for our clients if they want to have their members opt into that type of notice. But if a member has not opted in, you cannot send them notices that way. Or, put differently, sending them notices that way does not comply with your obligation as an association. You still need to mail that notice out. The notice needs to provide the date, time, and location of the meeting, and the association can adopt procedures for posting notice instead of mailing it out. And this talks about broadcasting on closed circuit cable. I know some communities do that. Just reach out to your counsel. It's so infrequent that I don't see a need to go through it in detail. Agendas. Every meeting except the annual meeting of an association has to have an agenda. That includes board meetings. So you have to designate in advance of the meeting what you're going to talk about, at least in broad topics. Now, just to be clear, another question that we get pretty frequently is, well, is a broad topic, is it good enough for us to put new business without any specificity in there? My answer is no, because the statute was changed literally last year to clarify that you need to have an agenda with specific items. And that's not specific. New business is, well, here's the stuff. That's not specific, in my opinion. So you need to have an agenda that contains everything that's going to be discussed and voted upon during that meeting. If it's not on the agenda, you probably can't vote on it during that meeting. There are other things you can do, which we'll get into later, to have the vote anyway if it's a board meeting. But if it's a member meeting, the only other alternative might be to get a written document that is signed by whatever percentage of the members you otherwise would have needed to vote at that meeting. And that's going to be specific to your community's governing documents, whether that's authorized or not. So moving forward, let's see. Members do have the right to participate in every meeting of the association, whether that's meetings of the members or otherwise. Members can attend, they can videotape or audio tape every meeting of the association. They can speak for at least 3 minutes on every agenda item. Now, the important part here, there are 5 policies that I recommend every single community in Florida have. One of them is a policy that this note says you can adopt that governs how, when, and how frequently the members get to speak at meetings so that you get your business done, whether the members like it or not. The goal here is to actually be able to do what you need to do to run your business, run the association. It's not to curtail member speech. It's not to cut off the rights of the members. And it's not to say you can't speak at a meeting. It's to make sure that the association gets to do its business. But if you look here, members can speak for at least 3 minutes on each agenda item. If you don't have a policy, you really might not have the ability to cut that member off when they go to 7 minutes, 20 minutes, an hour and a half, other than by getting them thrown out of the meeting by police. So I suggest that every community have this policy. It's something I prepare for most new clients that join me at the firm, because I think that it's extremely valuable to be able to do business at your meetings and not just be stuck with an owner who wants to talk for 45 minutes. That policy can also say that members can't cede their time to somebody else, because that happens during a meeting fairly frequently if you don't have that policy. Well, I like what that person's saying, so I'm going to give them my 3 minutes. And then it becomes a Spartacus situation. You get my 3 minutes, you get my 3 minutes, you get my 3 minutes. And it turns into, okay, well, this individual is now talking for 45 minutes and you can't get anything done during the meeting. So that's a lot of words to say. I strongly suggest you have a policy governing members' right to participate in meetings. That's one of 5 that I suggest every community have. We'll go through the rest of them later on. Member meetings, quorums, and decisions. A quorum is 30% of the total voting interest of the association, unless your bylaws say otherwise. And a decision is made by a majority of the total voting interest present at the meeting, in person or by proxy, unless your governing documents say otherwise. So keep in mind, we're saying 30% is a quorum. If you have that 30%, you can have a meeting. If you don't have that 30%, you haven't reached a quorum and you can't have your meeting. If you reach that 30%, a majority of those present, whether they're voting in person or by proxy, submit their ballots for whatever the item is, and you need a majority of those ballots to say yes in order to approve an item at a meeting. Pretty straightforward. Now, I mentioned proxies. This is just a document that basically authorizes either someone else to vote on your behalf, or it specifies I'm basically voting by mail. That's really all a proxy is. To be valid, this needs to be dated, include the date, time, and place of the meeting for which it's given, and be signed by the person who is authorized to execute the proxy and actually did so. Proxy is only effective for the specific meeting, so we don't do general proxies that are good forever. You might have a power of attorney. That's a different story. That's not a general proxy. But a general proxy is generally not something you're going to use in an HOA. It's going to expire. That specific proxy, the limited proxy, is going to expire 90 days after the date of the meeting for which it's given. What this means is if you continue a meeting for 100 days, every proxy that was signed for that meeting probably needs to be replaced because it's no longer valid. They're revocable at any time by the person executing the proxy, and the proxy holder may appoint a substitute proxy, meaning I'm saying this person votes in my place rather than this person is voting in my place and voting this way. Copy is just as good as the original proxy as long as it's a complete copy. We talked about general versus limited. Both limited and general may be used to establish a quorum, but only limited proxies will generally be used to adopt a vote on behalf of the proxy person, the person that is giving the proxy. Now, we talked a little bit about covenant enforcement. Let's get back into it for just a second. Regardless, and this is red because it's a change in the law last year. Any change in the law that we're looking at is probably going to be in red in these slides, just so you're aware. So these are new laws that were either revised or newly put in place. Notwithstanding any covenant, remember we talked about, okay, well, I don't care what your governing documents say, Florida law overrides it. This is one of them. Any HOA member may display up to 2 of the following flags in a respectful manner: the U.S. flag, the state flag, military flags, including the Space Force and Coast Guard, POW/MIA flag, or a first responder flag. Homeowner can fly 1 U.S. flag and 1 flag from the list above from a freestanding flagpole. What this means for practical purposes, if that person has a flagpole, they can display 4 flags on their property. And you may not be able to preclude them from having a freestanding flagpole, but there are size limitations, and you can have certain things in your governing documents that govern that issue. We talked about installation, display, and storage of items. When I mentioned earlier, you can't restrict someone according to this new law that was adopted last year by the Florida legislature. You can't stop them from installing something, storing something, or displaying something on a lot that's not visible from the frontage of the lot, meaning if you're looking at the door from this area behind the door, from the street, all the way from boundary to boundary of that property, or from an adjacent lot. Okay. You can't govern any one of those things. Now, some ways around this. Another problem with the statute. What about the view from across the lake? The lake across the lake is not an adjacent lot. Okay. Across the community common areas is not an adjacent lot. So we do have issues with this statute. There are people working on it right now, including many from our firm. We have 22 attorneys. I believe there are 4 or 5 that are currently trying to clean this up, including myself. But it is a mess of a statute. Now, some ways around the statute. This says that installation, display, and storage of items you can't govern. But let's say, for example, someone starts installing a bunch of pavers in their backyard. You can't see it from an adjacent lot of the frontage, which means you can't stop them from installing it based on this law. What you can stop them from doing is if that causes a drainage issue and water starts trespassing into an adjacent lot, starts trespassing into common areas. And by trespass, I just mean it's flowing from this lot and it didn't before. Those types of things, those secondary violations are still things you can govern despite this statute because they're not covered by the statute. Okay. Conditions on a lot are not governed by the statute. It's installation, display, and storage. If you can see it from over the fence, let's say you have a 2-story that's adjacent to this lot and you can see it from the 2nd story, it's still an enforceable violation. So there are a bunch of things. I don't want to give away all the secrets, but the bottom line is, and that's partially because you never know who is on this webinar that might take that back and cut that loophole out so that the associations, again, for some odd reason, can enforce 50-year-old restrictions. But we're going to move on to the next thing. Just know that there are other rules and regulations that might not be enforceable. And the next thing, by the way, is some of the other items that we'll get to later today. Fair Housing and Americans with Disabilities Act. People with disabilities, I won't say they have stronger rights than anyone else, but the Florida and federal legislatures have put laws in place so that they are protected from having equal access to their property and the community and the benefits of the community. You might have to allow reasonable, sorry, I couldn't think of the word accommodations for some reason. Reasonable accommodations, reasonable modifications of your regulations and your property to allow someone to have equal use of the property. Florida-friendly landscaping is another one that the association can't regulate against. No one seems to know what the heck Florida-friendly landscaping means other than environmentally friendly is essentially what it comes down to. Energy devices is another one. When you talk about solar panels, the association can control the location as long as that's not going to impede the use of the solar panels, meaning it's not going to make them ineffective. But you can't tell someone you can't have them. One thing that I have seen being successful is requiring an owner to actually sign an agreement that says that they're going to bear responsibility for the increased cost. If you're in, let's say, an HOA that's a townhome community, and this is actually a common area roof that they're putting the solar panels on, it wouldn't be something if this is a separate roof, but if you're in a community where the association maintains the roofs, you can require that the owner pay the cost of removing and replacing these when you need to replace the roofs or maintain them, that any damage that's caused by the installation or maintenance of the solar panels is the owner's responsibility, etc. Finally, the over-the-air device rule is basically you have to allow a satellite dish to be placed on a lot with size limitations that are in that federal law over-the-air device rule. And with similar limitations on the location where you can govern the location of these satellite dishes, but you can't make someone put it in a location where it's not going to be effective, meaning you won't get a signal. So these are just some of the things that the association actually can't prohibit. You can't prohibit clotheslines. that are not visible. There's just a lot that you would think you can do. Your covenants might say that someone can't do, but you have to allow anyway. So before you send an adamant, well, you're in violation and we're going to sue you immediately, I'd strongly recommend that you take our covenant enforcement class. The one that I taught yesterday should be helpful. You may not get credit for it if you go on our website at kbrlegal.com under the resources tab. That should be up by Monday or Tuesday of next week on our website. I would check that class out, and there's just not enough time for me to get into a lot of detail about some of these issues, but we do go into more detail in that class. Moving along, right to know the architectural standards. So bottom line, if you've got architectural restrictions in your covenants that someone needs to get actual approval before they install some kind of improvement on their lot, those standards need to be clearly stated or reasonably inferred in your governing documents, meaning it needs to be clear that the association has the right to set these requirements and what the requirements are in order for them to be enforceable. The fact that the association has the ability to review these plans and specs, but you don't have any criteria for what materials, sizes, colors, things of that nature, what is actually going to go into the appearance, any of these other things. If it just says the board gets to decide what's pretty and what's not, what's aesthetically pleasing and what matches the community theme, that's probably not good enough to be enforceable anymore. So if you've got the right to do that architectural review process and you don't have architectural criteria established, I strongly recommend that you run that by counsel and have them either prepare, or preferably the board prepares it, and then the attorney takes a look at what is in there and make sure that all of those restrictions are actually supported by the governing documents and are not prohibited by law. So just understand, you may have the right to review, that's not going to change. But you may not have a right to deny an application if you don't have specific restrictions in place as to the size, location, type, appearance, color, etc. of each one of these things that someone might be putting on their property. Again, another red line. If the association collects deposits for any reason, this is usually going to be either a tenant coming in and you take a deposit to make sure that expenses that are caused by the tenant are covered, or there's construction that's going on a member's lot. Those funds that are collected by the association cannot be commingled, meaning shoved together in the same account with any other association funds. You need a separate account for these deposits. Now, that doesn't necessarily mean you need a separate account for each deposit, but you need to be able to track the interest that's accruing on each one. I would suggest that it's probably easier to have sub-accounts that are separately tallied, so to speak, for each specific deposit. Once that project's complete, the deposit needs to be returned to the member within 30 days after the board is made aware that that construction is done, or the tenant's moved out, or whatever the reason the deposit was collected for is done. If the member makes a request for an accounting, here's why it's important to have separate accounts. From the association for the funds that were deposited, the association needs to provide that accounting to the member within 7 days after receiving the request. Keep in mind, usually we're talking business days when it comes to such a short time frame. This is talking calendar days. So you've got literally a week to get the owner this information. So you need to be able to pull that accounting up and not have to separate by pennies what is accounted for each one of these deposits that's been made to the association by the various members for various reasons. Another suggestion that I will make very strongly, recommendation more than a suggestion, have something in either the rules, the regulations, your governing documents, or at a minimum, the form that you have these owners fill out before they make that deposit that specifies who gets that money back at the end of this process, if there's any money left over. Because I've had situations where you get the money from the tenant, the member is saying, I deserve that money back because it pertained to my lease and the tenant destroyed my unit or my lot, but the member is supposed to get the money back, but the tenant's demanding it as well. Well, then you've got a conundrum because you're being shoved into the middle of a dispute that has nothing to do with the association other than the fact that you're the one holding on to the money and deciding who it goes to. So rather than have to literally file a lawsuit so that you avoid getting sued, which is called an interpleader, which basically says, Judge, please take this money. I don't know who it's supposed to go to, but I don't want to get sued by either of these parties that are demanding the money. let us out of this case and you decide who gets it. And please let us take our attorney's fees and costs, which, by the way, will often exceed the amount of the deposit. Let us get our attorney's fees and costs out of the court's registry and let us be out of this. My strong suggestion is have it specify in the agreement. It's not whoever pays it. It's not whoever wants it. It's in every one of these circumstances, this person gets it back, whether it's the construction company, preferably the owner who has a direct contractual relationship with the association will get this money back. And it's up to the tenant, the contractor, whoever it may be, to actually ask for that money back from the member. But this way, you've done what you're required to do pursuant to the contract between the association and these two parties. Moving forward, member rights to official records. This is policy number 2 that I strongly suggest every single community have, is how you will allow for records inspections. Okay, there is a bill that's currently pending that would require a searchable database of Florida HOAs to be created that must be accessible on the association webpage, and if you have one, including officer director names and contact information, whether you're self-managed or manager, your manager's contact information, a copy of the governing documents, a copy of the budget, and any reserve studies that were done. Now, this would be effective on July 1st of this year. So you might want to take another class after that to find out whether this went through. My suggestion is check out a legislative update shortly after July 1st, because that's probably when these will be going into effect, and you'll want to know either shortly before or shortly after that date as to what actually was adopted by the legislature. So as of this recording, which is February 29th, 2024, this is not the law, but I'm giving you the heads up that it might be soon. The current law does state that in addition to maintain a current roster of all members, the association has to maintain those designated mailing addresses of the members, as well as the designated email addresses of the members, and fax numbers if an owner designated that for purposes of receiving notices. I want to be clear, the fact that you happen to have an email address, the fact that you happen to have another address, if it hasn't been designated as a mailing address for purposes of receiving association notices, those are protected from disclosure, and you don't have to give those out to someone who has requested an inspection. If someone does request that you remove that email address or the fax number or the mailing record, the mailing address, the association does have an obligation to remove it altogether if you're not using it for that purpose anymore, meaning this is no longer my designated mailing address, take it out of your records. And it's kind of like the do not call registry, where the association has an obligation to say, okay, we'll do, and then remove it from the records. There's a whole list of official records of the association. I'm not going to go into detail because, frankly, here's the catch-all at the end is the most important one that we're going to talk about. All other, and when I say other, it means other than the rest of the list located above here, all other written records of the association that are not specifically identified in the statutes, which are related to the operation of the association. For practical purposes, what does this mean? Every single piece of paper, every email, every document that pertains to the operation or maintenance of your community is an official record, generally speaking. Now, there's a question about emails. I won't get into that in detail right now. That's one of those ask your counsel, because it's not 100% clear under Florida law for HOAs, even though it kind of is for condos, as to whether emails are official records that have not been produced to the manager or placed in the official records. But basically, even if you've got a piece of paper, you know, your notes from a meeting could be an official record of the association. Anything pertaining to the association's business could be an official record. That includes all of the ledgers for the individual accounts. So keep in mind, an owner can ask for another owner's ledger at any time. You're not going to just volunteer that information, because that would be a fair debt violation if you're giving out information regarding a delinquent account to someone who hasn't requested it. But if they request it via a valid records inspection request, everyone's entitled to that information. Now, we've got some timelines in here for specific items. Unless otherwise provided by law, you need to maintain these official records for 7 years. Now, I spoke about earlier some of the things coming down the pike. In condo world, you need to keep most of your records indefinitely, meaning forever. My strong suspicion, because the legislature seems to be pushing towards shoving together condo and HOA law and making them the same, you might want to consider maintaining everything forever, or you might take the complete opposite approach and say, I only have to keep it for 7 years now. If I get rid of it, I'm not going to get in trouble. So after that 7 years is up, I'm tossing it. That's up to the board. I would suggest that you make that determination and create potentially a separate policy, which isn't one of the ones I think you have to have, but a separate policy for how to destroy and get rid of association records after this timeline has elapsed. My suggestion, in order to make sure you're keeping in line with Florida law and what I anticipate within the next few years, Florida law will require, make sure that you're keeping these records for as long as feasible. And now that almost everything is digitized, as long as feasible really is pretty much forever. Moving along, the ballots, sign-in sheets, voting proxies, basically every piece of paper and electronic record pertaining to elections are part of the records you need to maintain. Those get kept for 1 year, and the acknowledgements, we'll get into collection later, but the acknowledgements that are made pursuant to 720-3085, which is the Florida statute that says you have to get an actual acknowledgement if you're changing the way you're notifying the members of what they owe for each assessment installment, that needs to be kept as an official record as well. There are certain records that the members are not able to get at that are privileged, meaning they're excluded from this records inspection. Okay, that's going to be anything that's attorney-client or work product privilege. Now, keep in mind, when we talk about attorney-client privilege, that's something that the board gets to decide whether to waive or not. An individual director, your manager, your attorney don't get to decide that attorney-client privilege should be waived as to any communications or any work that the attorney did. That is a board decision to be made at a closed legal meeting of the board. Medical records of owners or residents, this might be in connection with, and I know some people ask, well, why would I even have that? If there's a personal injury case or a fair housing request, meaning an accommodation of your rules for a disability to be served, that's why you might have medical records. That's not subject to disclosure. Information obtained in connection with a lease, sale, or other transfer of a parcel is not subject to disclosure. This is generally going to be your background checks. Personnel records of association or management employees are not subject to disclosure. However, what you're paying your manager, what you're paying those management employees, or what you're paying direct employees is all subject to disclosure. Electronic security measures, in other words, your passwords and other login credentials, association software and operating systems. Basically, you don't want to allow other people to manipulate the data just because you're giving them the opportunity to inspect the records. Okay. Continued personal identifying information. So you do have to give the name, parcel identification, mailing address, and property address. The rest of it is not accessible to owners. So that's, you don't give the social security number, driver's license, or any of this other information. And then if you swipe at a guard gate, which you shouldn't be doing, or you take a copy of a driver's license at a guard gate or get any other information at your guard gate, none of that is subject to disclosure via records inspection request. And again, those affirmative acknowledgements that we talked about, yes, they're official records, but they are not subject to disclosure. That's the changing your invoicing methods. Okay, we talked about attorney-client privilege. Only the board gets to waive that. And keep in mind, attorney-client privilege really only applies to situations where you are contemplating or in litigation. It's not just, well, we sent something to our attorney, you know, that would include amendments. Okay, well, that's not really privileged information. If it's, we need to amend our governing documents to stop this owner from violating the covenants, that might be privileged. Okay, moving forward, membership directories. So we talked about this. You can have a directory, which is a separate concept from the official records. The association can print and distribute that or email it to all the members. This is the information that can go through it. If you inadvertently disclose something that the owners requested you not disclose, that contact information, there is no liability of the association if it was inadvertently included in the other records that you produced. Now, if someone asked for something and you specifically sent it over, different story. You know, if someone asked for someone's social security number and you sent it to them and there was nothing else included in the production, that's not really inadvertent. So just keep that in mind. An owner can consent to disclosure of that specific information. Frankly, from my perspective, it's easier if the members don't do that so that the association doesn't need to review whether each individual member agreed to that disclosure. The association has to maintain an adequate number of copies of the recorded governing documents to ensure they're available. Put them up on the website, because I have no idea what the hell an adequate number of copies means. Neither does anyone else that I've spoken to about this issue. Moving forward, you need to make the records available after an inspection request is received. So after an owner serves the written request for access to the records by certified mail return receipt requested, you have 10 business days after that request is received, not after it's issued, but received. And it's 10 business days, not 10 calendar days, to provide the inspection, not offer it, but provide it. Meaning, make the records accessible to the member within 45 miles of the community or within the same county as the community, and give them the availability to either make scans, copy and paste onto a thumb drive, whatever it may be, or print copies if you've got that capacity at your office where this inspection is being created. If you don't have that capacity, you might have the obligation, and most likely do have the obligation, to allow them to pick out the documents they want copied for them, bring it to Kinko's, and the association is doing this, not the owner, because you don't let them take away any original documents. But the association makes the copies, and you can require the owner to pay whatever the cost was for those copies in excess of 25 pages, meaning the first 25 are free. But the owner has to pay for the cost of those copies before they can be delivered to the owner. That's up to the board. You can deliver them first, but I don't recommend it, because what's the likelihood that the owner's actually going to pay for it? It's not an assessment. You can't just tack it on to their account. So you kind of are stuck with that expense if you don't get it paid up front. You can have a copy available in the community, available electronically via the internet, and allow the records to be viewed in electronic format on a computer screen and printed. You do not have to, but you can simply bring a stack of boxes for all of the official records into your office and say, have at it. Cherry picking of individual documents is not required. Another thing that I hear people arguing about, and I'm dealing with an argument right now with an owner, is that please understand, you do not need to cherry pick. You do not need to create documents that don't already exist. Okay, so if you've got software, like let's say QuickBooks, for example, yeah, you can produce that report, but you don't have an obligation to provide the raw data. Matter of fact, you shouldn't be providing the raw data that can be manipulated. Now, I talked about this 10 business days to produce or the records. If you don't produce those records in time, a rebuttable presumption that the association intentionally failed to produce them will arise. That rebuttable presumption means that a court is going to presume that the association is violating the owner's rights. The consequence of that violation is a penalty of $50 per day starting on business day 11 up to $500 every day after that timeline is over, after that 10 business days ends. Now, keep in mind, I call this the $500 gift. You don't want to give this $500 gift. Okay. The other thing to keep in mind is that the owner is entitled to their attorney's fees and costs if they have to sue on this issue. Now, the good news when it comes to this rebuttable presumption, it is rebuttable, meaning that the court's going to presume this was willful. But if you can say, for example, I'm dealing with a situation right now where the prior management firm hasn't turned over all the records, the association has zero ability to produce them for inspection, and the prior management firm is refusing. By the way, it's not who's here on the line today, but that prior management firm is refusing to produce the records or provide the inspection so that it can be completed within the time allotted. The association has no practical ability to comply. Well, that might be an excuse that would justify that rebutting of the presumption that this was intentional. Hurricanes and floods and things of that nature are another reason that that rebuttable presumption might be defeated by an association. Now, again, this is policy number 2 that I think every community should have, governing the time, frequency, duration, location, notice, records to be inspected, and the manner of inspection for every records inspection. Okay, you can't require a proper notice to be shown for what this inspection is intended for, can't require a reason, and you can't limit the owner's right to inspect the records to less than 1 8-hour business day per month. So what does this mean? When you say per month, I'm actually reviewing and revising a policy that another attorney created right now. And it says, well, 1 8-hour business day per month. Great. So what this means is that the way that this attorney drafted the policy, okay, well, the owner can make a request on February 29th, and then they can make another request on March 1st. The way that I would draft it and suggest that you have it drafted by your counsel is every 30 days, not every month. Now, you might think this is no big deal because you only get one of these every once in a while, but the bottom line is as soon as you get one, you might end up getting none for 5 years and then someone who sends 20 of them in the next year. And if those 20 come in, you would only have to comply with 12 of them if you've got this policy in place. This is a huge burden on your manager. And if you don't have a manager, keep in mind, this is a huge burden on the directors directly. So you want to make sure that you've got something in place that says when, how, basically how these requests need to be made and how the association is going to respond and what limitations are going to be placed on the burden that's placed on the association. One other thing you might want in here is what are the charges going to be within the confines of the Florida statutes for the association to produce these records. So you can do up to $20 per hour if there's actually an administrative charge for retrieving and copying the records, and that exceeds a half hour. And again, you're limited to $20 per hour for that. And I mentioned earlier, you can charge for the cost of copying up to 25 cents per page for copies made on the association photocopier. Or if you don't have one, the association can have it done outside and charge the actual cost of copying supported by that vendor invoice. We talked about this earlier. If the owner brings in a portable device, they can scan the whole set of governing documents if they're capable of doing it within those 8 hours. Again, we talked about what happens if the association doesn't provide this on time, so we'll move on to elections. This is probably the easiest part of HOAs and still somehow the part that almost everyone seems to figure out once in a while how to screw it up. You look at what's in your bylaws. That's how you run an election. Next, it's pretty much that easy. Your bylaws are going to dictate how your election should run. So to avoid disputes over the validity of your election, a couple pointers: make sure that you eliminate nominations at the meeting. If you're allowing for people to state their intent to be a nominee during the meeting on the floor, make sure your governing documents actually allow for that. Don't eliminate nominations from the floor altogether if your governing documents allow for it and you haven't told anyone in advance that they need to submit their notice of candidacy before the election meeting. You want to make sure to give people the opportunity to serve, because in reality, it's hard to get people to actually be willing to do this right now. All of you that are on this, if you're not getting CAM credit for it, you're directors presumably of your community, or you're intending at some point to be a director, or you're trying to fix problems in your community. This is a thankless job. The only people that are going to thank you for what you do are probably your manager and your attorney. That's probably the only people you're going to hear thanks from. So just understand, try and allow people to serve as directors, allow people to vote, rather than trying to rule out all these ballots and rule out all these nominees. Make sure also to formally close out the balloting at some point so that you're actually allowed to count the ballots and leave at some point throughout the night. And so that you get an accurate count. You really shouldn't start counting the ballots, in my opinion, unless you're doing electronic voting, which does it automatically, which is another thing that I strongly suggest that most communities try to do, because it makes everything between elections and amendments much easier for everyone involved. But close out the balloting so that at some point you can start counting those ballots and go home. Moving along, elections: a person who's delinquent in payment of any monetary obligation to the association on the last day they can nominate themselves is not eligible to serve on the board. Now, keep in mind, the last day they can nominate themselves depends on what your governing documents say about whether nominations are allowed from the floor, or if you've got a condo style procedure or something similar where you actually have to nominate yourself or be nominated in advance of the election meeting. So that's going to determine the relevant date for this delinquency. Someone who's been convicted of a felony is not eligible to serve on the board unless their civil rights have been restored for at least 5 years on the date that they seek election. The date they seek election, again, is generally going to be the last date that they can be nominated. Now, if they submit their notice of candidacy 3 weeks before that 5 years is up, even if the election happens after that 5 years is up, they might not be able to serve. I'd run that by your counsel. And finally, someone who has pending criminal charges for felony theft or embezzlement involving association funds or property may not be elected to the board. Frankly, I don't think that's someone you want on your board anyway. Unless the bylaws say otherwise, the directors serve 1 year each. You might have staggered terms. You might have longer terms. That's totally up to you as to what's in your bylaws. Well, that's totally up to your bylaws, to be more accurate. A quorum of the members must be established to conduct an election in an HOA and any other business at the annual meeting, unless otherwise provided. Directors are elected basically by whoever gets the most votes wins. Let's see. Generally, anyone is eligible to serve on the board. They don't even have to be an owner or a member of the community. So just be aware of that. It's entirely feasible that someone that doesn't own a lot in the community can still be on the board. So, make sure that you have your attorney review your bylaws in advance so that you are aware of exactly who can and can't serve on your board before that election meeting. On the election day, again, we talked about, do you allow nominations from the floor or not? That's going to be based on what's in your governing documents and what the board has presumably decided in advance if it's an optional allowing nominations from the floor. If you don't have enough people that have nominated themselves where you need an election, because let's say you've got a 5-member board and 6 people actually want to serve, which good for you if you can find them, that election is not required. So if you've got the same number or less as compared to the number of open directorship seats during that election meeting, you don't need an election. If you've got more, you do need an election. If you've got a 5-member board and only 3 people threw their name in the hat, you've got a 3-member board with no election. Members have the right to vote in person or by proxy unless otherwise provided in the governing documents. I do have some communities that we represent that do not allow for proxies. So you basically have to send them a ballot and they have to send it back, kind of like the condo formal elections. Vacancies that are caused by the expiration of a term need to be filled by the election. If someone resigns or is otherwise removed, that's generally going to be by appointment or election, meaning you don't have to have a separate meeting. The board meeting occurs, at the next board meeting after this person stepped down or was pulled off the board. You, as the remaining board members, you just vote on who's going to take their place. The other thing that I've heard, which is dead wrong, they didn't hold an election for the last 3 years. So anything they did during those 3 years is invalid. And I'm suing the association and everyone else that I've ever met that's affiliated with this community. Well, you can file a lawsuit about anything. That doesn't mean it's a valid lawsuit. You don't need an election unless there are more candidates than vacancies. So if you have a procedure where, you're stating 40 days in advance of the meeting who is going to be a nominee, and there's only 3 people, and you have a 5-member board, or a 3-member board for that matter, you don't need an election. And you knew that in advance. You still have the annual meeting of the members, but you don't need to conduct an election during that meeting. You just make the announcement that those 3 individuals are on the board by acclamation, or just these are the directors, if you want to make it simple and straightforward, plain English. Now, if you have nominations allowed from the floor and your procedure is going to allow nominations from the floor, you won't have an advance ballot. You won't have that requirement that everyone nominate themselves in advance. That doesn't mean you can't allow people to nominate themselves in advance so that they can get an information sheet out to the members. We do have an entire class on elections, so I'm going to kind of skip through this because honestly, most of it is what's in the bylaws is what goes. Any election challenge, though, by the way, it needs to be brought within 60 days after the election results are announced. So if your election was on January 1st, chances are sometime in early April or late March, that's the last day that you can file an election challenge. If it's not filed within that time, it's subject to immediate dismissal. Again, electronic voting is going to be extremely helpful. It's allowed for any member vote, but the procedure and requirements are really specific. Bottom line, work with your attorney and a vendor that the attorney is comfortable with and that you as a board are comfortable with in getting this in place. But I do strongly suggest that every community association that's not already using this at least consult with an electronic voting vendor, because the percentage of people in your community who vote it tends to increase drastically. And those people that adopt, just like adopting email notices, those people that adopt electronic voting generally will also adopt email notices, which means that you're not mailing out packets to all of those people that adopted this. So your cost can go up, can go down, can stay the same, but your procedure is much easier because the electronic voting company is taking care of 90% of the effort and you got to do the other 10%. So skipping over the rest of that, election of officers is done by the directors. So we didn't talk about this. I'm going to get into who's who within your community. You've got your members. That's literally the people that own property in your community. You've got residents. They don't have to own property. They just live there. You got visitors, guests, whatever. Okay. Then you've got your directors. The board of directors is a group of individuals who run the association. They vote on most of the decisions that the association makes. Unless the members vote on it, the board gets to decide it without a member vote. Okay, that's 90% or more of the association's business is done by this group of 3 to 5 people. Now, the meetings need to be open to the membership for the most part, but the board gets to decide. So your directors wear a different hat, by the way, than your officers. Officers are generally going to be your president, vice president, treasurer, secretary. Okay, those are going to be the people that have specific responsibilities within the community. Now, if you have a manager and that manager is actually doing what the contract with management calls for, they're going to take over most of the responsibilities of the officers. They're not going to make decisions for the association. Your attorney shouldn't be making decisions for the association. That's what the board does. So all the board really does is make motions, second those motions, vote on them, or abstain and discuss the motions. Those are the only things that the board is obligated to do. The officers have specific responsibilities that may be transferred over and delegated to the management firm, depending on the terms of your management contract. Now, I'm not going to get deep into election fraud in a community association, but bottom line, any of these things that are fraudulent voting activities in a community association and an HOA in particular will constitute a misdemeanor of the first degree, meaning it is literally a crime to do any of these things. It's basically falsifying or bullying voting. That's pretty much what it comes down to. But please do read these slides when you have a moment. I do suggest that everyone read through these if you have time afterwards. I know that we're going through 2.5 hours, but I'm on slide 44 and we're over an hour in, so I got to move a little bit quicker than we have been. We talked about the various hats that the directors wear. The other really important thing that I need to mention is the board's fiduciary duty. Okay, the directors and officers have a duty to the members that exceeds every other duty in Florida. Your responsibility to do what's in the best interest of the association exceeds every duty that you might possibly have. You're basically a trustee of the association if you're on the board or an officer of the community. Now, that fiduciary duty, all it means is you need to do what you reasonably believe to be in the best interest of the association. The good news is, I hate to put it this way, but this is the way that I describe it. It's the highest duty imposed by law, governed by the dumbest person in the room standard. Okay, what that means is if you reasonably could have believed that what you decided on behalf of the board, basically how you voted or the actions you took, were in the best interest of the association, you're generally covered by what's called the business judgment rule. I mentioned this earlier. Okay, that business judgment rule, in turn, is assisted by the association getting guidance from experts. Now, I say experts, that doesn't necessarily mean these are people that would qualify as an expert in court, but you're taking guidance from people who know what they're talking about and get paid to know what they're talking about. Your manager, your architect, your engineer, your attorney, those people, if you take guidance from them and get it in writing, by the way, so that you can show that you took that guidance, then you're generally going to be protected if you follow that guidance. In turn, if you ignore that guidance, you're more likely to get in trouble for not following it. Okay. Moving forward, we talked about the power grab, who has what powers, board voting. We talked about the board members cannot vote by proxy or secret ballot at a board meeting, except when you're electing the officers So that's generally going to be during your organizational meeting, which takes place right after your election. Now, chances are you've already done that. So I'm telling you something you might already know. But bottom line, that's the only time that the board is allowed to vote by secret ballot. The board is allowed to make decisions in secret, but keep in mind that's only going to be during noticed, mention the word noticed, not just, hey, we're meeting with our attorney, we don't need to provide notice to the members. Not accurate. During a noticed attorney-client privileged meeting or a noticed meeting where you're going to be discussing employee issues. Okay. Those are the only two types of meetings that the association can close to the members. Members are entitled to attend every other meeting. Members of the board can use email to communicate. You cannot vote via email. So just understand there needs to be something after those emails that actually says, here's how we're voting. No director should be making unilateral decisions unless there's specifically delegated power or if it's an emergency. And when I say emergency, I don't mean, well, I wanted to sign this contract and no one was available, so I signed it. That's not an emergency. That's your emergency, but that's not an emergency. What I'm talking about is there's a hurricane and you need to shore up the property, things of that nature. So when that individual does serve a bad purpose or do these things that they weren't authorized by the board to do, just understand there's nothing that says you can't change officers midstream throughout the year. So if your president is taking the office of president a little bit too seriously and turns into a power-hungry beast, there is a way of just having a vote at the next board meeting to remove them. Make sure that's on the agenda in advance. And yeah, I understand you don't want to give them notice that that's what you intend to do, but it is necessary. So just make sure that that's on the agenda and that you take care of it. And you can change the officers and have everyone else on the board vote to say, you're no longer the president. You are now the vice president, and the vice president or whoever is taking over. So you repeat that potentially secret ballot process of deciding who is and is not each specific officer position. The officers and directors I mentioned have a fiduciary duty, and you must act reasonably within the business judgment rule. I mentioned that it's okay not to be right on occasion. Now, some of the things that are not mentioned here with that fiduciary duty, I make the joke, and it's only kind of a joke, that you've got three of your most important bills that you will possibly pay as a director who is paying association bills. The first one, and the most serious one, is your directors and officers liability insurance coverage. That policy needs to be paid and it needs to be current, because otherwise anything your directors and officers do is not covered by an insurance policy, and the things that they do in their capacity as directors and officers might not be protected, meaning that the association is either indemnifying and paying out directly to protect those people, or they're not protected at all and they need to pay to defend themselves in a lawsuit, which I'm sure none of them volunteered for. The other two are your manager. And again, I say this is only half joking. And the third one is your attorney. But the reality is these are, in my opinion, your three most important bills. If you're not making sure that these are the three people you're taking care of the most, and I say taking care of, what I really mean is communicating with and ensuring that you're doing the right thing in each instance, then you're probably making a mistake, in my opinion, because your manager, your attorney are going to know what you should do in 99% of cases, or at least can outline the risk if they can't specify what you must do under the law. Anyway, jumping off that soapbox, board meeting notices are required to specify and specifically identify all agenda items. We talked about this, except for emergencies. Board meeting notices needs to be 48 hours for almost everything, and that is posted in the community and either mailed or emailed to the members. If it is only mailed and not posted, it needs to be 7 days. If it is posted in the community, you got 48 hours notice, except in an emergency. Now, keep in mind, there are some notices that will require more notice. I'm sorry, some meetings that will require more notice than that 48 hours. Okay, one of them, unless the bylaws say otherwise, special assessment meetings, meaning you're adopting a special assessment, or meetings where you're going to be adopting rules regulating parcel use. Those require 14-day notices. So when I say special assessments, be aware that what I also mean is, well, a fine is being converted into assessment. and an individual self-help charge is being converted into an assessment. My opinion and the opinion of this firm is that that requires a 14-day notice, but it only needs to go out to the individual or individuals who are getting that special assessment against their lot. Okay, so again, 48 hours notice posted in the community, pretty simple. Put it on your website if you've got one, put it wherever else you want to put it, but it's 48 hours unless it's an assessment, special assessment, the annual meeting, or you are considering changes to the way that people are allowed to use their lots. You can post notice on the association website, like I mentioned. You can also use an app to provide these notices. That notice needs to include a hyperlink to the website or the mobile app on which the notice is being posted. It needs to include the agenda and all of the attachments to the agenda, etc. But there is the ability of the association to adopt a rule to simply send an electronic notice to members whose email addresses are included and who have agreed to accept notices that way. You can either attach the notice and the agenda and everything else to that email blast, or, pardon me, you can include the links that I mentioned earlier to the website where all of that information can be found. Directors serve without compensation completely, except for and I say this is a volunteer role, I mean that. Participation in a financial benefit that everyone else got, reimbursement for out-of-pocket expenses pertaining to the association, which are subject to any approval procedures the association has in place. I'm working on one of those right now for a client, by the way. Recovery of insurance proceeds derived from a policy that's maintained by the association for the members' benefit, not your own insurance policy. Fees or compensation that are authorized in the governing documents or by majority vote of the members, voting in person or by proxy at a meeting of the members. Or if a developer's rep or the developer itself serves one of these positions, that developer can be paid for that role. Generally not by the association, by the developer, but I've seen it kind of both ways. Kickbacks, this is another one. This has been the law in condo land since I think 2017. Fortunately, the legislature didn't make it quite as bad because in condo land, it's a misdemeanor to accept a kickback. Here, there are severe civil penalties, so still don't do it. And if you don't understand what a kickback is, that's fantastic. Hopefully that means you've never accepted one, but it's basically accepting something of value in exchange for using a vendor, or using a service, using a, buying something or paying for something. So those kickbacks are not allowed. Now, keep in mind what you are allowed to do is accept food at a business meeting that's worth less than $25, meaning they're charging less than $25 per person, or a service or good received in connection with a trade fair or education program. So if you were at CAI last week on Friday and you saw us there and you happen to collect some of the stress balls that I love to throw at Jeff Solomon when we're at events together, or the pads, the pens, etc., those are all acceptable. They're not gifts. They're things that are in connection with a trade show, and you're allowed to accept those. Officers and directors must be removed from office if charged by information or indictment, meaning charged with a crime by a court of criminal nature, for forgery of a ballot envelope or voting certificate, theft or embezzlement involving association funds or property, destroying association records in connection with basically hiding another crime, or obstruction of justice. Directors and officers must disclose to the association anything that may reasonably be construed as a conflict of interest at least 14 days before the board votes on that contract or enters into the contract that's the subject of the conflict. There is a rebuttable presumption of a conflict which was created last year if any of these things happen before the association provides, or I'm sorry, if any of the acts occur without the prior disclosure of the association. Basically, you enter into a contract directly with the association and you're a director or officer or relative of one of those people, or you hold an interest in that corporation or that other entity that proposes to enter into a contract or does business with the association. Bottom line, contracts between an officer, an association, and a director are acceptable. It's not a bad thing necessarily to have a conflict. But what you want to make sure is that it's being disclosed to the members that you have that relationship, that the board properly votes on it, which means 2/3 of the unaffected directors are going to vote in favor of the contract. And you are not participating in the voting by the board, and you're walking out when the board is discussing and voting. You can be part of the presentation, you can be part of the member discussion, but once the board starts its own discussion and starts its voting, they want you out of the room so that you're not interfering, including by just giving someone dirty looks. Okay, so they don't want that pressure on the other directors. The other directors have to vote by 2/3 vote of the other directors present, and you as a director or officer will abstain from that voting, meaning you're not going to vote on that particular issue. You're not going to participate in the discussion. Now, the members do have the ability, if none of this was done, meaning you didn't give the proper disclosure, the members have the ability to cancel that contract, and the association is only liable in that event for the reasonable value of the goods and services provided up to the time of cancellation, regardless of what other things the contract calls for. I'm not going to go through this in detail because we have, an entire class on just conflicts of interest in HOAs and condos, so you're welcome to attend that one or check out one of our past presentations of that class. So moving on, you are guilty until proven innocent. You are off the board if you're charged with an information or indictment. The vacancy is filled if you end up with a finding of not guilty, or basically the charges are dropped. You are placed back on the board, and the person that substituted for you temporarily is basically taken off the board. We talked about excessive gifts. If the board finds an officer accepted that more than $25 worth of food or something that's not in connection with a trade fair, keep in mind that the board is obligated, legally obligated, and is doing something wrong if they don't remove that director from office. The vacancy gets filled according to law until that director's term is over. Basically, that means that someone else gets appointed to fill that vacancy. Again, vacancies on the board. It's filled by an election if it's caused by the expiration of a term. If it's caused by literally anything else, generally speaking, the directors get to appoint someone else to fill that vacancy. The only exception really is a recall. Okay, if you've got a recall and the petition doesn't include the proposed officers that are going to step into that role, the board gets to remove, or the individuals get removed from the board, and the board gets to appoint the other directors who now need to replace those who were recalled off. Member participation at board meetings, again, same as member meetings. The only distinction between member participation at board versus member meetings is they don't get to vote at board meetings. Only the board gets to vote. An owner, again, just like a board meeting, just like a member meeting, an owner can record the entire meeting. You do need to give access if a handicapped or disabled person says that they can't attend because of a valid reason in the location where you want to hold your meeting. You do have to give them the opportunity to attend. Sometimes I've done that by offering Zoom, even if the association wasn't previously offering it, or holding the meeting in a location where that person can attend. Now, the alternative, that member can attend by phone. That might be an acceptable solution to them. It might not be, but again, we've got a whole class on fair housing issues, so I would check that one out. Committees really don't exist unless and until they're actually created by the governing documents or the board. Generally speaking, the board is authorized to create whatever committees they want, with however many people they want. Really, the only exceptions are you will have, if you want to do fining or suspension of use rights, again, that's in our covenant enforcement class, but that's generally going to be something that you have to have a specific committee of 3 individuals who are not directors, officers, managers, or their family members that are willing to serve on that violation committee is really what it comes down to. Conflict of interest disclosures, we kind of went through. I don't think there's anything we didn't discuss here, so we'll move on. What is a meeting of the board? Let me be clear here. There's no such thing as the Sunshine Law in Florida HOAs. Okay, that Sunshine Law is something that pertains only to municipal government. It's the state, it's the county, it's the city. It's not an HOA. There's something similar, but if someone talks about the Sunshine Law in a Florida HOA, Hopefully it's not an attorney, or that attorney is just trying to use language that people will understand. But the bottom line is there is no sunshine law in a Florida HOA. What does exist is a law that says a board meeting occurs whenever a majority, a quorum of directors meets to conduct association business. The question then becomes, pardon me, what does it mean to conduct association business? Some attorneys, including myself, will tell you that conducting association business is making decisions. And that if you're not making a decision and you've explicitly made the statement that there will be no decisions made during this meeting, it's not a board meeting. Some will say anytime you're discussing association business, including when you're out on the golf course or at the bar talking about association business as a quorum of directors, that's a board meeting. Now, what approach you take, totally up to you. I would specifically get that opinion in writing from your counsel so that, again, the board is relying on advice of counsel and not just something that they heard during a class 5 years ago. Okay, moving on. By the way, that same requirement of openness and etc. does apply if you are having a committee meeting of a committee that's deciding to vote to spend association funds on behalf of the board, or any architectural review body that's going to make a decision as to an architectural application in your community. Moving on. How to get off the board, recall we mentioned. Failure to satisfy this class requirement or the certificate, which is a temporary suspension. Criminal charges that we mentioned. Receipt of an excessive gift over $25. You can resign in writing. You become more than 90 days delinquent in the payment of any monetary obligation of the association, including fines, by the way, possibly even including key charges. I would suggest you give notice of that in advance of pulling someone off the board for it, but it's not required in an HOA. It is required in a condo. Now, the other way to get off the board is you can die. I wouldn't recommend that method. So we'll talk about some of these things, a few gems all board members should know. But if any of these issues is something you're not knowledgeable about already, please, anything that you don't get answered today, I truly welcome everyone that's on this meeting to reach out to me directly. as@kbrlegal.com is my email address. You'll have it in the slides, but that's the easiest way to reach me if any questions come up that don't get answered today. Board and member meeting minutes. Let me be clear. This is not paragraphs of everything that everyone in the entire meeting stated. There's nothing that says you can't do it that way, but frankly, I think you're wasting your time if you do. All it has to be is what was the motion, who voted, who made it, who seconded it, and how did they vote? That's it. And who abstained. That's your meeting minutes. What was the motion, who made it, who seconded it, who voted, and how? Done. Your meeting minutes should be no more than a page or two, depending on how many issues that you've got that you're discussing. And I literally read meeting minutes that were 7 pages long this morning. And it was, here's what every member came up and said. Okay, well, you can do it that way, but just know you don't have to. Now, minutes should be maintained in a written form or in another form that can be converted to writing within a reasonable time and maintained in the official records of the association. They don't need to be verbatim records of everything that was discussed, stated, etc. Now, we talked earlier about how, okay, well, there is an alternative to voting via email if you don't have the time to have a board meeting. There are a few. One is ratifying the decision at the next board meeting. Now, this shouldn't be 6 months later, but if you have a meeting scheduled in a week and you want to sign, for example, I've got several communities that want to sign our representation agreement, but they're waiting for their board meeting. Nothing wrong with that. But you can sign the agreement, have the president sign, and then ratify the decision at the next meeting. The alternative is a written agreement that is unanimous among all the directors. Under Chapter 617, we talked about the not-for-profit statute. A lot of community association attorneys do not realize that you have the ability, because there's no conflict in the statute, in my opinion, you have the ability to have the board sign a unanimous vote. It becomes a written, basically a resolution of the board, and it fully replaces a board meeting. Now, keep in mind, I'm not suggesting that you should use either of these things very regularly. But if it's something, in my opinion, that you're 100% convinced is going to be unanimous at the meeting, then yeah, maybe why wait? Other than for purposes of satisfying the members to feel like they got to participate or at least hear the discussion. Now, keep in mind, if you use ratification, you need to start the discussion from scratch as though you didn't already sign this document. Okay, but you can do it that way instead of waiting to sign that contract. Again, though, it shouldn't just be the president deciding to sign the contract and then hoping that it gets ratified at the next meeting. Moving on, right of access to parcels. The association only has the right to enter onto somebody's lot if the governing documents say so. In a condo, it says you have that right in the statute. And an HOA, because HOAs have been around for so much longer, you don't necessarily have that right unless your governing documents allow for it. Okay, generally speaking, the members don't get to vote in an HOA on material alterations and improvements. This is basically changing the visual aspect of something in your community. Usually we're talking about common areas. The members generally don't get to vote on that. Now, there are some exceptions to that. One, if your governing documents say that the members get to vote on any material alterations, of course, you have to comply with your governing documents. The other thing that might be in your governing documents is a provision that says, that doesn't say anything. It's silent as to material alterations, but it says any expenditure of over $5,000 by the board has to go to a member vote. Okay, well, you got to comply with that. My suggestion is you might want to consider amending your declaration so that that dollar figure is a little higher and you have a reasonable opportunity not to have that member vote on something that's fairly straightforward and easy, but there's nothing that says you can't give the members the power to make decisions on pretty much anything. Now, I'm not necessarily advocating for taking power away from the members, but the reality is most members have no idea how to run a community, how to run a business. And so giving that decision-making capacity to them, frankly, is part of what caused a lot of the problems that happened in Surfside, a lot of the problems that happened in other communities where the members don't want to spend the money, the members don't want to do X, Y, Z, and it keeps the association from being able to comply with its responsibilities for maintenance and operation under the governing documents. So that's why I say leave these decisions to the board, who will hopefully at least have the training of a class like this. Amendments, speaking of which, will generally require an affirmative vote of 2/3 of the voting interest of the association unless your governing documents say something else. There is a specific format. There's lender consent concerns. I'm not going to go into detail. Again, we do have a class on updating your governing documents. It's something that we do for our clients on a regular basis. Some clients come to us just for that purpose. Developers, keep in mind, cannot exercise unilateral power of amendment if the amendment would alter the general plan of development. What this means for practical purposes is that the developer who is in your community can't adopt, okay, well, we're going to have 22 amenities and we're going to have a small community and it's going to be fantastic. And then say, well, you know, I thought that was a great idea, but we're going to cut it down to 5 amenities. And instead of the 300 lots that you bought in thinking we were going to have in this community, we're going to develop 35 other phases and it's going to be a 5,000, an 8,000 lot community. Okay. So if you are changing the general plan of development, the character of the community, the members get to vote on that. The effective date of the amendment is whenever you get it recorded. You need to provide copies of the amendment unless a copy of the proposed amendment was provided in advance, which is the way we generally do it. And in that case, you basically send a postcard that says, here's the recording information for our amendment once it gets recorded. Now, if you don't think you can get the vote for an amendment, but you think it's important, keep in mind that you do have the option to start by amending the amendment provision to reduce the required quorum and reduce or reduce the required vote. You can do either or. So you can cut it down from that 2/3 of the entire community, less the voting interest that have been suspended, to 2/3 of whoever shows up at a meeting, as long as there's a quorum. So these are things that we try and get a little bit more creative than some other firms in saying, hey, if you can't get it done this way, let's try and get it done the other way. Because once you're done with this, then you move on to the substantive amendment you wanted. And by the way, it'll be easier if you adopt electronic voting as well. That tends to result in a higher voting percentage. Leasing restrictions will generally only apply to specifically the people that bought in after the leasing restriction was adopted or who actually voted in favor of the restriction. So it's not going to apply to anyone that voted in against it and still owns that lot. Except in 2021, the law was changed so that basically any leasing restriction that says that you can't rent for less than 6 months at a time, or you can't rent more than 3 times in a calendar year, that's going to apply across the board to all owners, regardless of whether they voted, regardless of when they bought in, etc. The rental amendment restrictions don't apply to associations with 15 or fewer owners. So there's a few of those that we do work with, and we're happy to take those on. But the bottom line is, most of the time, you're going to be subject to everything except this last bullet point here. Moving on. Okay, we're not going to go through this in depth. We do have a leasing and guest restrictions class. I know I keep referring you to other classes, but again, 188 slides in less than 3 hours is not an easy thing to do. So we're going to go ahead and move on, but understand you've got the slides here. You're welcome to read them if you have questions and you think something wasn't answered during this class that's important to you or your community. Do seriously feel welcome to reach out. I generally respond to those emails within a day or two. You can adopt rules and regulations pertaining to the use of common areas, rec facilities, and the lots if the governing documents so provide. They need to be reasonable under Florida law. They need to actually be supported by the governing documents, meaning if you don't have leasing restrictions in your declaration or your bylaws, you can't adopt a rule that says, well, now we have these rights. You have to have the right to adopt the rules in order for them to be valid and enforceable. The rules and regulations generally were required to be recorded, but now they're not. I still suggest you might consider recording them so that everyone and not just your membership is on notice of what's in those rules and regulations. The only downside of that is anytime you want to change them, you also have to record the amendment to the rules and regulations. So moving forward, I mentioned you need to give 14 days notice before you're going to change or adopt any of those rules. These are generally going to be adopted by the board, by the way. So again, we talk about the difference between a member meeting and a board meeting. This is done at a board meeting, period. It's not, the members don't get to vote. They might be angry about it. They might not like it, but the bottom line is the board gets to decide. Now, just like the board gets to decide today, if you have your election in 6 months and the new board decides to change and cut out half of what you did, that's their right too. Moving forward, Marketable Record Title Act, known as MARTA. Basically, I'm going to put this very simply. If your governing documents, your declaration was recorded more than 30 years ago and you haven't preserved the covenants that are in your governing documents, they might have expired and become unenforceable, which means that the owner that's got pink and purple polka dots on their house, the owner that's not paying their assessments, you can't really do anything about that until you revitalize your covenants. Okay, this is a very in-depth topic, and frankly, I'm surprised we don't have a class on that. I'm going to start talking to my partners about putting one together for us because this is an important topic. I've had 3 clients in the last year who didn't realize that their covenants were unenforceable because of this law. So the bottom line, just make sure that your attorney is telling you when this deadline is coming up. It's the first thing I look at for every community that my office in Orlando takes over and starts working with is, okay, do you have all of your declaration, bylaws, and articles of incorporation recorded? What is your expiration date if you're in an HOA? Okay, that it's just that important because if you lose those enforcement rights, it becomes significantly more expensive to go revitalize like what we mentioned here. Now, at October 1st, as of October 1st of 2018, at the first board meeting, except the organizational meeting after the annual meeting, meaning not the one that you generally will hold that night of the meeting or right after the meeting, but the next real board meeting is what people refer to it as. You have to mention this law, and my suggestion is you should be getting a date from your attorney as to when this expires. Now, I say when this expires, I say that it's based on the date of recording the declaration. In reality, it's based on the date of recording every deed from the developer, which is called a root of title. The bottom line is it's a lot cheaper, quicker, and easier, and it's an earlier date to make sure that you're covered if you just go by what's in the declaration rather than pulling up every deed in your entire community. because we work with communities that are 3, 5, 10,000 lots, and that could be an enormous expense to try and pull every single deed from the property appraiser's website to see when that initial deed was given. Moving forward, you got to let process servers into your community, someone that's going out to serve something affiliated with a lawsuit or that just gets served by a process server under Florida law. You got to allow them in. So if you've got a gate, you need to allow them into the gate. If you are doing any of these things, which is you are paying your manager and the association or association served contain more than 10 lots or have an annual budget in excess of $100,000, if you are using a manager, this doesn't mean you have to have a manager, although that's my recommendation for every community in Florida. But if you are using a manager, that individual needs to be licensed if these circumstances apply to your community. Okay. Someone who is just doing ministerial work, meaning, you know, they're just a clerk, not a manager, is not required to be licensed even if this stuff does apply. It's only if they're doing the things that are bullet pointed under this first item up here. Controlling or dispersing funds, preparing budgets, etc. Those are the things that are going to cause you to have a licensed manager versus an unlicensed individual. There are professional management practice standards. CAM and the firm must discharge their duties loyally, skillfully, diligently, dealing honestly and fairly, blah, blah, blah. Bottom line, the manager also owes a fiduciary responsibility to the association. That'll be more specifically stated as to what that entails within the contract between the management firm and the association. Normally, management is going to include an indemnification provision in their contract. What that basically means is that the association covers the expense that they end up with if they get sued for something that they did as your manager. Now, it's going to cover ordinary negligence. That indemnification cannot cover anything that violates a criminal law, derives an improper personal benefit, either directly or indirectly. That's the conflict. Is grossly negligent, is reckless, is in bad faith, is done with malicious purpose, meaning you're going after one owner that the manager doesn't like, or is in a manner exhibiting wanton and willful disregard of human rights, safety, or property, meaning you're doing something inherently dangerous. Anything else, basically ordinary negligence, is going to be covered under that indemnity provision of almost every management contract I've ever reviewed. Now, here's another point that I didn't mention yet. Every single contract that your association signs should be reviewed by your attorney before you sign it, even your landscaping contract. Okay, I've got a dispute going on right now with a company that was supposed to be servicing a lake and mucking it and cleaning it out, and there's no attorney's fee provision. There's no specificity as to what they were supposed to be doing, other than a vague list of items that, according to my client, they didn't do. Okay, you want this to be clear enough so that a judge that's looking at this contract can clearly say, yep, association, you're right. They didn't do what they were supposed to do. You also want it to be clear enough that it's not directly beneficial to the other side of that transaction and directly against what the association wants to be in there. Now, moving forward, I'm going to skip defects because it's something that our firm does. If you have those issues come up where you've got a problem, a construction defect in your community, we do have a board certified construction attorney on staff that can help. But honestly, if you've got that issue, it's not something we should be dealing with in a basics class like this. That's more advanced than what I want to go into today. You do have emergency powers, which I'll skip through, but just know if there is a declared state of emergency and there is a risk that that emergency is going to cause damage to people or property in your community, these emergency powers will kick in. And that includes, now that the statute was changed back in 2021, that includes a pandemic, not just a hurricane as it was initially intended. So just understand, if there's a declared state of emergency, whether that's nationwide, statewide, or locally in your municipality, these rights are going to kick in and they stay in effect as emergency powers until that state of emergency is shut down by whoever it may be. Now, keep in mind, you may have 5 different agencies declaring a state of emergency. Until they're all shut down in your particular area, this state of emergency is still in place and you have these emergency powers. You're welcome to read through them. We basically just took what's in the Florida statutes and put them in plain English is really what it comes down to. Driver's licenses, you can't swipe. I mentioned that earlier. You can only swipe a license if it's required to pay for goods and services with a method other than cash, verifying age for age-restricted goods and services, or to prevent fraud in certain financial transactions. None of that is really going to apply to the association. If you inform the person of what information will be collected and the purpose for what it'll be collected, and the person says it's okay, you can swipe. But generally speaking, you can take the information, you can photocopy the driver's license, you can't swipe it. Budgets, I'm going to skip through most of this, and keep in mind, you're still going to get your credit even though I skipped through some of this, because we're allowed to skip, I think, 3 or 4 of these sections altogether. I'm going to give the basics on each one of them, even if I skip it, but we're now at about less than 40 minutes before we're supposed to be ending and starting the Q&A. So I'm going to make sure to skip through some of this. Back to budgets. This is your best guess of what it's going to take to maintain and operate your community over the course of the next year. It is not a dollar for dollar analysis of the exact figures. If you match your budget by the end of the year, you're either really lucky or you're probably doing it wrong, because you're either limiting your spending and backing into your budget, or you limited your budget so you're just not doing things that you really need to be doing. The members have the right to know exactly what it's supposed to cost to properly operate and maintain. Note the word properly there, okay? To properly operate and maintain your community. Not to do it the way that they're going to be happy with what they have to pay for assessments, the way that it should be done in accordance with your governing documents. Properly maintaining the landscaping, doing all of the things that you would want to do to beautify the community, okay? Now, you might not have to update the tennis court if you've got one. Fine, not a problem. But if you're not going to trim the bushes because you don't want to spend the money, that's a problem. That's a lack of maintenance. Okay, make sure that the budget the board proposes includes all that. Keep in mind, if the members don't like what's in the budget, they do have the ability to propose an alternative budget and then vote to adopt that alternative budget. But you, as a board member, have a fiduciary duty to give an accurate depiction of what you reasonably believe it's going to cost to maintain the community and operate the community properly over the course of the next year. If you're not doing that, it might even be a breach of fiduciary duty to budget improperly. So make sure you're not cutting back. Make sure you're not watering down the budget to keep the assessments artificially low. Just do what you really think it's going to take, because the alternative is you end up with not enough money to do what you need to do, or possibly you end up needing a special assessment, which could be enormous because you didn't budget properly for your assessments. Not doing that work, by the way, is just going to mean that it costs more to do it down the road. So you can have a project that's 10 grand this year that you didn't want to spend, but because you wait long enough, it's going to cost 100 grand or $1 million, because the position and the item, the asset of the association continues deteriorating over the course of several years, and you're not maintaining it the way that you should. So make sure to do what you're required to do. Let the members screw it up if that's what they want to do, and propose and adopt an alternative budget. Notice and adoption. You're basically giving notice that assessments will be considered. Non-emergency special assessments, you need 14 days notice. For the budget adoption meeting, technically you only need 48 hours notice. You also need to provide a copy of the budget or notice that it's available to the members if they ask for it. I would suggest you send it out so that everyone has the opportunity to say, we don't like your budget and we want a different one. After the budget's adopted, the association does need to provide a copy of the budget or written notice that a copy is available upon request at no charge to the member. And if it's requested, this is a records inspection request for a copy of the budget. You got your 10 business days after receipt of that written request. Use last year's expenses to plan for next year's budget. Monies in the operating section of the budget are not restricted to any particular purpose. They're not reserves unless you have an actually established reserve. Reserves are not required in an HOA unless they're established by the developer, they're established in the declaration, or they're established by the members. They're not statutory at all. That's only in condos and co-ops. So understand the fact that you've been putting money away for something doesn't make it an actual reserve. So that doesn't mean that you can't use it for whatever you want, but you might not have to get the member vote to have those reserves used for a different purpose if they haven't formally been established by the association. So that's something you would want to run by council is, can we use these funds for something else? Here's how we think this reserve was created and how the money's been saved since that date. You're basically going to have your operating and reserves. Those are your two budget categories. The budget for each association needs to state basically the dollar figures for each category, and those categories need to be basically line items as to what categories of assets that you're reserving for, services, expenses, income, etc. So here's just a list of operating expenses you might have. Pardon me. We talked about reserves. I'll skip through that. Other than to say, there are two different types of reserves. One is where you are doing a straight line method, which is you take however long you think this asset's going to last. Hopefully that is based on a reserve study that's been performed to find out how long an expert in that field thinks it's going to last. But if you decide to do it on your own, that's kind of acceptable. But a straight line reserve would mean that this item, let's say it's the roof, is supposed to last 10 years before you need to replace it. It's a little bit old and it's only going to last 10 years, but it's cheap. It's only going to cost 100 grand to replace this entire roof on the clubhouse. Great. Okay. Huge clubhouse, cheap expense compared to what it would cost normally. If it's going to cost that 100 grand in 10 years, you're budgeting for $10,000 every year to cover that straight line reserve. Okay. The alternative, and by the way, you can adjust that over the course of those 10 years because you should really be getting that item, those assets that you're reserving for checked out every couple of years to see whether that estimate is still accurate. An alternative is you basically just adjust for inflation every year. That's not the way I'd recommend it because it's far less accurate as to what you're going to need, but just expect that the cost of this is going to go up from when you got this reserve study done in 2024 versus when you actually have to replace that item in 2034. It's going to go up potentially astronomically as to what you actually need. And if you're only budgeting for that 100 grand and it costs 200 now, you're $100,000 short. And you need to either get a loan or potentially pass an emergency special assessment because your roof is falling off. Okay. But bottom line, that's one option, is the straight line method. The pooled method is essentially where you have enough at any given time to cover the items that you expect to fail at any given time, but you kind of put all the money together and you can use the funds instead of it being a straight line where you're only accounting for that for one particular item. You're now allowed to use that money for any of these reserves where the assets are in the same pool. So you might have 15 different reserve assets in one pool, and you can use that money that you have in the pool for any of those items, those components that start to fail or need that long-term maintenance performed. So moving on, you generally need a member vote to waive or reduce the reserves in any given calendar year for your budget. If you want to use the reserve for a different purpose, that also requires a member vote, and that's generally in an HOA going to be a majority of those present in person or by proxy at a meeting of the members. You can also terminate reserves by a majority of the total voting interests of the association. Now, we talked about special assessments a little bit. Essentially, you've got your 14-day notice. You've got your notice to the members of what the special assessment is supposed to be for, what the anticipated dollar figure is, and when the meeting will be held, where, etc. Just like you would for any other normal meeting, but the agenda item is going to be a little bit more specific as to the nature and dollar figure for the anticipated special assessment. You're then going to have your meeting. What vote is required depends on your governing documents. And then after that special assessment is passed, you're going to notify the members that, hey, the special assessment was adopted, it's now being levied, and your payments are due this way. Okay, but you got to do all those three things. It's notice of the meeting, have a meeting and have meeting minutes, and then tell the members, here's what's due and how and when and dollar figures. All right. Keep in mind a special assessment or anything else that is considered a lienable expense under the declaration is collectible by the association in the same format as any regular assessment. We do have, again, a collection class that you're welcome to attend, and all of these can be seen on our website. Moving forward, special assessments we talked about, financial reporting. This is generally going to be something that's done by your manager, or at least created by your manager or your accountant, depending on who you're using. So I'm not going to go through this one in detail. Just understand this slide is the Mo Money Mo Problems rule. Basically, the amount that you actually have to delve into the specifics of your community's records is going to depend on the dollar figure that you bring in any given year. So if you only bring in $100,000, you really only need what's basically a ledger, a cash receipts and expenditures report. And as you gradually go up, you go from 1, 2, and 3. If you've got 500,000 or more, you're going to prepare an audited financial statement. And as you go through this list from 1 to 3, you're basically going to go up, 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 up in the level of review that the person that's going to be creating these records is going to be doing. The other thing to keep in mind, the only one of these that really requires a CPA, it's the reviewed and the audited. So if you've got the cash receipts and expenditures, that's your QuickBooks ledger. If you've got the compiled financial statement, that's still going to be potentially done by the association or the manager. It's basically the statements based on what's already in the association's records, no review, no assurance of accuracy. And then the next two are going to be a little bit more in-depth review. The audits are going to come with notes that might be helpful to the association that you might want to actually review, even though I know a lot of people think it's boring, and frankly, so do I. But that can contain information where, the auditor is going to look to the extent of this contract wasn't signed by the vendor. So, you might want to get a signed contract, or you might want to use that as an excuse to renegotiate your contract. So these are things that I've seen in practice as being actually practically really helpful. Moving forward, changing the reporting level. Again, that's a member vote. Keep in mind, there are specific percentages of this. I'm not going to get into the specifics. There are required disclosures that your accountant or manager should know to put into these financial reports. You can, to some extent, rely on them, which is why I'm not going through a lot of this in detail. But keep in mind, they need to do this the right way. So my suggestion is, if you're doing anything beyond just the very basic, well, we only bring in 100 grand, my suggestion is that you get a CPA or some kind of formal accountant involved in this process. The Division of Corporations does require that you do certain filings between January and May 1st of every year, basically your annual report. That's something that your registered agent should be handling for you. Then you got your annual income tax that also needs to be paid. Again, not really something that's part of this discussion, but just be aware that just because you're a not-for-profit doesn't mean you don't have to file a tax return. Now, another issue that I've had come up is what happens when we have money left over from last year. You'll probably have to pay tax on that, but that does not convert the association into a for-profit entity. Just understand, you're allowed to have money left over. Frankly, it's a necessity for most communities so that you have operating funds for January of the following year. It does not convert you into a for-profit entity. Contracts and bids. All contracts must be in writing if it's for services or can't be performed within a year. Practically speaking, again, have your attorney review all contracts to make sure that they include all of these items here in the practice tip. If you are going to have a contract, the aggregate cost of which is more than 10% of the total budget, including reserves, that's a big contract. The association does have an obligation to obtain competitive bids for that contract. You don't have to accept the lowest bid, meaning cheapest isn't best. You can do this without obtaining those bids in an emergency. If the business that you want to contract with is the only provider in your area that actually does this type of work, you also don't need to obtain bids. And if the contract was executed before October 1st, 2004, any renewals are not subject to competitive bidding. Now, there are a bunch of types of contracts that you do not need to do competitive bidding for. I want you to understand this. All the employees, attorneys, and managers are among those lists. The contracts must be in writing because they're all for services, But keep in mind, you do not need to bid out your attorney. You do not need to bid out your manager. There's nothing that says you can't or shouldn't. But my perspective is you work with the company that you're most comfortable with and that you like the most. Hopefully that company also knows what the heck they're doing. But bottom line, you do not have to bid out professional services. A contract with a manager, if made by competitive bid, can be for up to 3 years. A contract with an attorney or some of these other professionals doesn't have to be for a defined period of time. Okay, we basically have an indefinite arrangement with our clients because it renews automatically. That evergreen clause is allowed. Moving on, if a contract was awarded under competitive bids, any renewal is not subject to those bids if the contract contains a 30-day opt-out provision, meaning you can cancel whether for cause or not on 30 days notice. If you can't do that, you need to get competitive bids even for renewals of those contracts. Associations whose declaration or bylaws provide for competitive bidding may operate under the provisions of the declaration instead of what's in the statute. Generally speaking, you will not have competitive bidding in your governing documents. If you want to use a different procedure than what's in the statutes, my suggestion, propose an amendment to your governing documents and that'll control instead. Communication services. So basically this is bulk contracts for internet and cable. You can sign those a lot of the time. Frankly, it'll mean the association gets some cash infused into the community in exchange for the ability to use the property of the association for the system of this vendor. Any contract that is for this bulk internet service, bulk cable service may be canceled by a majority of the voting interest present at the next regular or special meeting of the association, meaning it's not at any board meeting and it's only at the next meeting of the members. Whether that's the annual meeting or a special meeting doesn't matter. When you sign this in, let's say you sign February 29th, if your election is tomorrow, that's their only opportunity to cancel this bulk contract. And it requires a motion by one of the members and a majority vote, I believe, of the community. So keep in mind, it's not just a, well, this one person doesn't want it. It's this one person was smart enough to know that the contract was signed, smart enough to know they have the right to make this motion, and frankly, is able to garner the required votes to make that happen. Moving on, discontinuation by members of these communication contracts. If the board signs one of these contracts, they must provide and are deemed to provide, if they don't, that hearing impaired or legally blind owners, basically people that are not able to use the service, don't have to pay for it. A parcel owner who receives supplementary security income under Title 16 of the Social Security Act is not entitled, is not required to pay for this. And food assistance, people that receive food assistance pursuant to DCF, is someone else who will not have to pay for this service. They can discontinue it. When I say they won't have to pay for it, they have the option of disconnecting it and may not be required to pay any operating expense charges. If they get the service, they still pay for the service. I've had this argument made that someone could discontinue or keep the service in place and still needs to pay. Andrew Cohen just asked, and I usually don't go through the Q&A, but yeah, you're in the wrong class, Andrew. You need to take the condo class in order for you to get the certificate. I'm sorry, but I don't know exactly when the condo class is being taught. Jerry might have one coming up, but you're welcome to take a look at the calendar on kvrlegal.com and you'll get that information there. Moving on.
I know we have one at the end of March.
End of March, there's your answer. So hopefully that falls within your 90 days. And sorry that you took the wrong class, but we did make it pretty clear both in the sign up as well as at the beginning of the class that this was HOA specific. So hopefully you still got something out of it. Anyway, other providers, if an owner chooses to go with another provider, that's fine. They can't be required to pay anything of value to get something from another provider. In other words, if you've got a bulk cable contract and someone says, I'm going to use a different one, they're allowed to, but that doesn't excuse payment of the portion of common expenses that's affiliated with that contract. We talked about use suspensions and voting suspensions. This is a covenant enforcement issue. I'd suggest you check out our covenant enforcement class, but this is a useful tool to get people in line with what they're supposed to be doing in your community. Essentially, you've got the authority to fine. I don't recommend doing it because it doesn't resolve anything. And you've got the authority to suspend use rights, meaning use of the amenities in your community pursuant to Florida law. What you need to have in your declaration if you want to suspend it is voting rights. There are very specific procedures that we go through here for having these suspensions kick in. If it is for a violation, then all three findings, suspensions, and voting rights, suspension, use rights, and voting rights are going to require a board meeting followed by a 14-day notice. And like I mentioned earlier, that finding committee meeting needs to be basically handled by a finding committee that is composed of 3 individuals who are not the board, not officers, not managers, or any of their family members, and are willing to serve on that finding committee. The finding committee says, yes, we adopt the fine suspension, then great, it goes forward. They send notice to the member that the fine or the suspension was adopted, and that's in place. If they say no, that decision's final, and there is no fine or suspension regardless of what the board wanted. So this is why I say it's cumbersome to even get this done. In an HOA, you cannot lien for fines unless the fine is $1,000 or more, which is even more from my perspective, why it's a waste. I suggest you just go forward with standard covenant enforcement, which means you send letters, you seek an injunction, or you perform self-help, subject to the restrictions that we talked about earlier. Again, I'm going to kind of have to skip through some of this because it's already almost 10 after 4, and we've only got until 4:30, I think, to get through all of the actual materials, and we've still got 70 slides. So moving forward, let's see, we talked about suspensions. Keep in mind, you can suspend use rights and voting rights for both monetary violations, meaning non-payment, and now that's 90 days delinquent in any monetary obligation, and or for violating other non-monetary covenants. So this use right suspension or the voting right suspension pertaining to a 90-day delinquency only requires a board meeting. You don't have to have a finding committee if it's done for the purpose of addressing a monetary obligation. Now, again, I'm going to reiterate because I don't want anyone getting in trouble saying, Alan told me that I could suspend voting rights. That has to be in your governing documents according to Florida law. Or your governing documents have to automatically adopt all future amendments to the Florida statutes. Okay, if your declaration was recorded before 2010 and doesn't include that language, you're probably not able to suspend voting rights. Moving on, I'm sorry, yes, voting rights. Moving on, and again, I apologize that I have to skip through a lot of this, but honestly, we've got really good classes on these subjects. And frankly, I really would love to have just an 8-hour all-day blitz of here's everything that a director needs to know. So if you want to spread that over time, you take one of these classes every other week or every month or something of that nature. I teach at least 2 of these classes every month, not a board cert necessarily like you're in now, but some of these what we call electives like covenant enforcement. We talked about some of the covenants that pertain to your community, some of the things.
I'm sorry to interrupt. Just wanted to call everyone's attention to the chat portion. There is a link for the slides of this presentation. I just wanted to run, so you can use that as a refresher and actually look at the slides that we might have glossed over during the webinar, but you can do that. And also the evaluation is there as well. Thank you.
Thank you, Jerry, and thank you for the opportunity to actually take a sip of water because my mouth was getting a little dry talking this much. Moving on. Covenant enforceability, you've got certain covenants that might be enforceable, some that might not. Really, what you want to do is run that by your attorney if you're not entirely sure. Moving on, you can extinguish a discriminatory restriction, meaning literally there's discrimination in the provision itself. No Jews, no blacks. I've actually had to extinguish provisions like that here in Central Florida. I haven't seen any of them in South Florida. I haven't really reviewed many declarations that have them in North Florida, but You'd be amazed at what might still be in there because the board basically said, we don't care what's in here, we're just not going to enforce it. Now you can actually have it removed by a specific process that doesn't necessarily require an amendment or an amendment and restatement to your governing documents. Again, we've discussed you need to have authority in your governing documents to actually restrict all of these things. There is authority in the statute to do certain things. One of the things I do want to mention is this $100,000 rule, which basically says before you file a lawsuit, and this is statutory, in the name of the association, involving amounts in controversy over $100,000, the association must obtain a majority vote at a meeting of the members where a quorum has been attained. Keep in mind, this is a shield for the association, not a sword for someone who is being sued. What I mean by that is if someone tries to argue, well, the association didn't get the vote, that doesn't mean your case gets dismissed because you didn't get the required vote. What that means is, and there's specific case law on topic here, that your case gets basically put on hold until you get the vote, and then you go right back to where you were. So don't think that this is something that an owner is going to be able to kick your case out of court over unless your attorney maybe makes a mistake, or frankly, more likely a judge doesn't understand Florida law on this topic. Disputes between an association and owner, any use of the parcel is going to be subject to pre-suit mediation. That's basically a process where the parties get together, they try and settle it, and if they're not able to, then the association gets to move forward to litigation, or the owner gets to move forward to litigation, depending on who sent the offer. But there's an offer for pre-suit mediation that's sent. It's essentially a document that gives 20 days to respond and agree to mediate the dispute. And if the owner doesn't respond to that, or the recipient doesn't respond to that, and actually agree to one of the 5 mediators that the individual that sent out the letter has selected in the letter, the good news is the other side doesn't get to recover their attorney's fees and costs, even if they win. So when we send this letter out to the owner and we wait the 20 days and they don't respond within those 20 days, agreeing to mediation by certified mail return receipt requested sent to my office, chances are they're not recovering their attorney's fees and costs, even if they win that lawsuit. So it can embolden some communities to go after things they normally wouldn't. Moving forward, so the procedure, this is another one, by the way, of those policies that I strongly recommend every community have. How are we going to address covenant enforcement? Are we going to send 2 or 3 notices through management and then send it on to the attorney? Are we going to use what's called self-help and actually physically go onto the property and cure a violation, which is another major issue in Florida law right now? Because there's a recent case that says if you have that remedy, you basically have to use it no matter whether you think that it's risky to use it or not. And you can't get an injunction if you don't try that remedy first of going onto someone's property and curing the violation. And I think that that's a mistake under Florida law. When I say mistake, I don't mean it's wrong under Florida law. I mean, it's a terrible idea. So bottom line, that might be something you need to do. And it's something that I am working on several amendments for clients right now to remove, because the association doesn't want to go and, have a vendor climb on someone's roof and try and fix it, and someone ends up shooting through the roof and shoots them in the foot. The bottom line is we're in Florida. You never know. So my strong suggestion is to have 2 amendments and a covenant enforcement policy. Those amendments are to remove self-help unless you're actually going to use it. For example, landscaping issues and things like that are a little bit more innocuous. And then the other one is to make every attorney's fee and cost incurred by the association in enforcing its rules, regulations, covenants, etc., make that an assessment against the lot that caused the attorney's fees and costs to be incurred, so that the entire membership is not paying the cost of the association going after this one owner. Now, in collection land, you already have that right. In covenant enforcement, you don't have an automatic right to recover the attorney's fees and costs unless your declaration specifically says so. Most declarations will say you need to actually file a lawsuit to recover attorney's fees and costs. But what happens when you've sent out 5 notices and right before you file your lawsuit, the owner cures the violation, you're out $1,000 or whatever the dollar figure may be? Sorry, but you're out that money. You've got no remedy to recover it because your declaration says you can't. So my suggestion is everyone that's got a provision like that in their declaration, amend it out, make the change, make it so that, and this is the way that I present it to the members, make the person that caused you to have to pay this money have to pay it back to the association so that it's not something that you bear indefinitely. It's something that if the association gets it back, the next year's assessments can maybe be lower. Moving on. I just talked about prevailing party attorney's fees. We talked about the enforcement process. You do want to be reasonable in this process, but you still want to be as aggressive as you can within reason so that owners don't get the idea that they can just do whatever they want in your community. You want to make sure that this procedure, this policy that you're putting in place for covenant enforcement, for collection of assessments, for member participation at meetings, it automates all of these processes and keeps this process moving along without the board having to step in and schedule a meeting, make a decision, then the manager or the attorney is able to move forward. You want it to be the violation's still there, move it forward, done. Moving along, self-help versus injunction, we just talked about, but here is the case law that I talked about. Moriello came out in 2022, basically says if you've got a right to do that landscaping, then you have to do it. Meconico, which is the next case, basically says that if you've got that right, because attorneys from 2022 until August 2023 were basically arguing, okay, well, we'll go out and do the landscaping, but we're not going to do anything else because that's an unreasonable risk to put our vendors in. And the judge in this case basically said, yeah, that risk is too speculative to say that someone might get hurt, might cut an electrical line or a utility line, might get shot, etc., might get verbally assaulted or physically assaulted. That risk is too speculative for me to justify as a judge that you shouldn't have to do the self-help if you've got the right to do it. Now, this is a very deep legal interpretation that I'm happy to discuss with anyone that wants to, but the bottom line is if you've got self-help in your governing documents, you have to at least send a demand and try it before you can file a lawsuit for an injunction under Florida law as of right now. We talk about assessments and foreclosures. Again, this is where I started in 2010 with the firm and in the industry, doing nothing but collection for 4 years. So I want to make sure this is often more important to enforce this than any other covenant in your community, because it's the one that means that you actually have the funds to do all the other stuff that your community needs. If you're not doing collection on a rational, procedure governed basis, you are probably losing money as an association and costing your members money. You need to make sure that you are adequately protecting your association by pursuing unpaid assessments. Again, this is another one of those policies that I strongly recommend every community have. And I also strongly recommend that it say the association after X amount of dollars is due, or after X amount of months of a delinquency on an account is actually my preference. The association is going to send a notice of late assessment. And if the notice of late assessment doesn't result in payment, that's going to go out to the attorney, and the attorney handles it from there without any board involvement unless there's a settlement offer made. Period. That's simple. Okay, if you don't have that in line, my opinion is you're probably wasting time and you're probably not getting what you should from your members. It's their obligation to pay these assessments to fund the operation and maintenance of their own community. If they're not paying it, then you should be moving forward on that. I mentioned the invoice delivery method. If you change the way that you're notifying the members of what method of payment the association is going to accept, for example, you go from coupon books to ACH and check only. Okay. If you're changing that method, each owner individually needs to agree in writing that they are going to adopt the new method. Anyone that doesn't adopt that new method of delivering these invoices by a written reservation, you still need to use the old method until they agree. I think this is ridiculous because you could end up over the course of 5 years using 5 different methods of communicating this, and you could need to use 5 different methods at the same time of delivering these notices under this law. But that's the law as of right now. I mentioned the notice of late assessment. This is basically a letter that we usually prepare a form for our clients to use. The reason that we do that instead of the firm taking over immediately when an account is delinquent is because you can't charge attorney's fees for this letter. So some firms will send this letter out and just charge the attorney's fees to the association and tell you, well, sorry that you can't recover it. That's kind of your problem. I'd rather charge you one time, 1 hour of attorney's fees to prepare that for you, and you get to use that form indefinitely unless and until the statute changes and the form changes in the statute and we need to make changes for you. But this is basically the first notice that goes out before the association can charge any attorney's fees for unpaid assessments. Now, I want to be clear, when you're talking about collection of assessments, all of the attorney's fees and costs are owed immediately, no matter whether you file a lawsuit or not, regardless of what's in your governing documents. So that is one thing, when you're worried about the assessments, you're worried about whether or not you'll get your money back. The attorney's fees and costs are collectible even in that second notice, not the notice of late assessment, but the next one that goes out. The other thing to keep in mind is some firms like ours have special collection programs that'll allow the association to defer the entire cost of all collection efforts until that file gets closed out, which means you might not be incurring those attorney's fees and having to pay them out on a monthly basis if you're under one of those types of programs. Some other firms have it. Ours definitely does, and I think ours is one of the best around. Moving forward, collection, you can only charge late fees only charge late fees if your governing documents allow for it. The max that you can charge for those late fees is $25 or 5% of each installment. Don't charge interest on late fees. Don't charge interest on interest. You do have the right to charge interest no matter what. It's 18% unless your governing documents provide for a lower figure, but your late fees need to be only based on each installment. So if you have quarterly assessments and it's a $100 assessment, you absolutely cannot charge $25 per month in late fees. The payments that are received by the association do need to be applied in a specific way. So when someone says, well, I paid the amount of the assessment, so you need to close out my account and treat it as paid in full. No. Not only is that inaccurate under Florida law, but the next bullet point here, restrictive endorsements, which is, well, this is for payment in full from January through December. Those are meaningless under Florida law. You don't have to give any credence to them. But that payment that is received by the association gets applied first to interest, then late fees, then attorney's fees, then costs, or actually cost and attorney's fees together, then to the delinquent assessment. So don't think that someone that makes the amount that was owed for assessments, that they pay that amount and they're good to go. If any interest, late fees, attorney's fees, or costs also accrued. We have a collection class, and I frankly don't have time because we've got about 7 minutes until I want to get into the Q&A, but check out that collection class, Should I Pay or Should I Go? These are just the notices and some mortgage foreclosure issues that we don't have time to go through today. But do feel free to take a look at them. And if there are any questions about anything that's in the slides, I genuinely mean it. Please reach out to me and ask the questions. You do have to have adequate insurance to cover the common areas, facilities, and association property that the association is responsible for. That what is adequate is going to be specific to your particular community. There's nothing in the statute that says you have to have a specific dollar figure. So run that by your manager. You might even need to get the insurance company to do some kind of appraisal. I don't know. I don't know. You probably do. So moving forward, fidelity bonds are another thing that you have to have for all persons who control or disperse funds of the association. If you've got a management company, they probably are covering that already. If it's anyone on your board directly who is controlling the finances, you probably have to have that fidelity bond for them. Look into what your insurance coverage actually covers. You might not have the coverage that you think you do. Another thing to keep in mind, and I don't think we're in here, but I will mention that the statute of repose on a construction defect lawsuit was changed last year. It used to be 20 years, then it was 15, then it was 10. It's 7 years from the date a certificate of occupancy is issued for your community. So if you've got problems with the construction of your community, you need to push those forward immediately, because sometimes that 7 years is not enough time, depending on when the developer turns over control of the community to the members. Moving forward, transfer fees and estoppel certificates, frankly, it's covered here. There is a bill outstanding that might change this, so I would suggest that after July, you take a collection class. You might want to take it now if you don't fully understand these issues, but I just don't have the time to go through it all in detail. Again, feel free to reach out to me if you've got those questions, and you will still get your certificate, because we are going through the materials that we must address, which, by the way, I've already gone through. So Stay around because you need to in order to get your credit, but don't think that because I'm breezing through some of this, you're not going to get it. The Federal Fair Housing Act, we talked about that earlier. Again, we do have a class that's specific to this issue, which is why I don't feel bad skipping through it, because you can just go on our website and watch my old class. You won't get credit for it, but you can get the information that you need. There are a bunch of us, by the way, within the firm, and frankly, there are other firms as well that teach classes on these issues. But these are basically, in very short terms, laws that say that a disabled person is entitled to the same use of the property, of the premises, and the same rights within the community as everyone that doesn't suffer from that disability. What that means is that if they request an accommodation of the association's restrictions, you are required to provide it if they can demonstrate, or it's obvious that accommodation is going to serve the disability. There is an analysis that the association should be doing. This is policy number 5 that I strongly recommend for every community, because I'm dealing with 2 fair housing complaints right now. And the bottom line is you do not get your fees and costs back on these, even if you prevail, meaning you could end up spending 50, 100 grand, win, and get nothing out of it other than, well, we don't have to pay the owner a whole bunch of money. Good for us. This is the service animals, emotional support animals. There is a distinction. Those are not pets, by the way. So your pet restrictions don't apply once someone has established that this is an emotional support or a service animal. There are ways of determining whether it's a service animal, whether it's a support animal, or if it's neither and it really is just a pet. So just keep in mind, again, I would strongly suggest you review this. If you don't already fully understand all of it just by reading our notes, hint, hint, you won't. Take the class, or at least watch the class. Again, I don't see any reason that a director needs to get credit for those classes. It's just a matter of knowing that the information is in your brain when these issues come up that you might not otherwise know about or see. Let's see, let's move on to recalls is one that I will go through, and then we'll be done for the day. I'll just kind of breeze through the last few things. A recall is a really highly technical procedural matter. If you get a recall petition in, you need to get it to your counsel immediately. And when I say immediately, I mean within the hour. The reason for this is that within 5 business days after you get the recall petition, you need to actually hold, oh, it's on the next slide. You need to actually hold a board meeting and decide whether to certify the recall, meaning to actually remove the individual who the recall petition says they want off the board. If the board doesn't meet within the 5 days, the association can be sued, and that's 5 business days again. But the bottom line is your attorney needs to go through every single ballot that was submitted as part of this petition to see whether it was valid or not. If it is procedurally valid, you have no choice. You pull these people off the board. If it's procedurally invalid, then it's up to the board and the individual director whether that person is going to jump off or not, whether you want to fight the issue or not. But I've seen where, we've had larger communities that had a recall, and it's taken several attorneys 2 full business days to get through the materials that we need to review to make sure that each one of those ballots was procedurally proper, meaning that it's not invalid. So the biggest thing that I can mention is this is the one way to get someone off the board without an election, other than, the things that we've mentioned earlier that will cause them to be removed no matter what. It is also extremely time sensitive, and it can be extremely costly to make sure that it is either done right by the members or reviewed right by your counsel. So just make sure that you get it over to your attorney immediately if you get one of these in. So moving forward, turnover. If you're already under developer control or still under developer control, make sure that you know when these turnover criteria are triggered. It's generally going to be what's in the statute, 720.307. But if you are under developer control, you should be reaching out potentially to an attorney that's not working with the developer already to get separate guidance. Now, the attorney that's working with the developer, the builder, whoever it may be, has a legal obligation to the association. So I'm not suggesting that you should be cutting off that attorney and saying, well, you work with the developer, clearly we can't trust you. that obligation stays with the association regardless of what happens. Just like when the board changes, that doesn't mean you have to clean house. Okay, if I end up with a new board, none of whom I've ever worked for before or with, more appropriately with, because we don't work for the board, but if that board completely changes over, I still represent the association, the corporation. So just understand that turnover doesn't mean that you have to clean house, get rid of the manager, get rid of the accountant, get rid of the attorney. It means that you have to get to know those individuals and decide for yourself whether they are the best person to do the job. Now, it is 4:31. I know that we need to get into some of this stuff, get into the Q&A, but just be aware there are obligations during and after turnover that the developer will still have. So now that we've gotten through as much as humanly possible within exactly 2.5 hours, Jeff, I see that you've jumped on, and I'm going to open it up to you for whatever you need to get across. Thank you, everyone, for being here, and hopefully you'll stick around for the Q&A. We certainly appreciate Jerry's presence and his participation here, because without him, we wouldn't be here today.
Thank you, Alan. Always a pleasure. You do a great job.
Thank you. So I'm going to apologize in advance because I made the mistake that I tend to make of looking at my calendar as to how much time we had, and maybe we only had 2.5 hours. So I apologize, but I will get through all this. And again, I welcome anyone that doesn't get their question answered because they didn't have time to submit it to just reach out to me directly. Jerry, did you want to add anything? I know you got to cut out a little earlier than I do.
Well, first of all, it's always a pleasure to be able to work with KBR. Guys, this is a great law firm. I also want to let everyone know, thank you for the privilege of your time. I'm sorry I can't stay on any longer, but I have another, like a back-to-back meeting. But so we'll get through these answers for you, and then please feel free to reach out to Alan or to myself, and we will get you the answers required. So thank you very much. There is a recording as well that you can reach out to Jeff to get. If you missed it, or if you joined late and you missed a part of it, the slides are available. And once again, thank you, everyone. We look forward to helping you in the future.
Thank you so much, Jerry. All right, so getting to the Q&A, I know that there's one person that submitted multiple questions. So I'm going to take one from that person, and then I'll skip to the next person and jump back to just so that we get everyone answered. Please address delegable duty. So that is basically where the association through the board delegates certain obligations to a specific individual. That could be the manager. It could be, pardon me, one of the specific directors or officers, or it could be someone that has nothing to do with any of this. But the bottom line is it's essentially going to be the board at a board meeting delegating the authority to someone who is not the entire board to do something. That's literally all it means. All right, so that answers that question. Moving into Caridad Pimienta's question. For a condo, how do you go about choosing a property management company? Well, a good one just left the meeting. That's one. Yeah. You just really, you reach out to a bunch of property management companies. My suggestion, if you've got an attorney that you're working with, is that you ask them who the management companies that they work best with might be, because the bottom line is the ones that your attorney works best with, that's going to mean that your attorney is as efficient as possible as well. And you might reduce your overall attorney's fees and costs by not working with someone in a management capacity that doesn't necessarily know the industry, understand how these things work, and is kind of on board with how your attorney works. I won't name names because, frankly, naming a bunch of other management companies when we are hosted by one would probably be bad form, but I do welcome anyone to reach out, and I will give you a list of 10 to reach out to in your specific area without giving any kind of preference to any of them. You make your decision as a board. So that one was answered. Moving on, unless Jeff, it looked like you might have something to add.
I was coughing. You're good.
Oh, perfect. Okay, next question by T. Straub. Frequent attendee, by the way. Thank you very much. Yes. Regarding the budget, can the board delegate a $75,000 budget to a chair's discretion without keeping oversight of the money and the chair? Or is the board responsible for how that money is spent? Does delegating the budget violate the fiduciary duty? Depends whether there is an actual violation there. If the individual that's being delegated this authority is someone who ran a multi-million-dollar company and was never accused of doing anything wrong with the money, that might be a great idea to not have to deal with that. However, most of the time, my opinion is you're going to want that oversight, even if it means that this individual is entitled to spend whatever they want to spend, but they got to send receipts to the treasurer for whatever they've spent. Some kind of oversight, I do think, is in line with the board's obligation to make sure that the association's money is spent appropriately. So bottom line, there's nothing that will automatically disqualify what you've described from being appropriate or safe, but I think the safer course of action and the more risk averse course of action would be to make sure that you've got some oversight of the use of that money. I would also suggest that, again, it be someone who is specifically involved with the category that the money is being spent for. Like I said, someone who's already run a multi-million-dollar business that was an engineering firm, and the money is being spent on engineering expenses. Or one of the directors individually who already has a fiduciary responsibility, whereas this individual, if it's not a director, officer, or manager, probably doesn't have that fiduciary responsibility. That doesn't mean they'll do anything wrong, but they might not bear the same responsibility. Andrew Cohen, we have someone who wants to put a swing set up on the front yard common area for their autistic child. Do we have to make that accommodation? It frankly will depend whether the autistic child needs that accommodation in order to have the same enjoyment of the property that the rest of the members have. My suggestion would be that you can make alternative suggestions. You might consider if there is a side yard or a backyard that is blocked by a fence, possibly also for the safety of that individual, might be more appropriate that go in the backyard. But I can't say offhand whether that being in the front yard and seeing everyone walking around might contribute to the actual function of that swing set. So I can't give you a straight answer. And frankly, that's one you need to send to your attorney, because the bottom line is there's not an easy answer to that question. Okay, when document changes are recorded, we're talking about amendments. Is there a document required to be recorded with the amendment documents confirming that there was a vote and the voting percentage or count by which the amendment passed, or some kind of required language? Our bylaws have been changed several times without any member vote. Your bylaws might have been changed by the developer before the turnover occurred. Usually the developer, like I mentioned earlier, has the ability to do that without recording any kind of certificate, without identifying any vote was taken, etc., unless it would change the character of the community. If that was done by your board, then yes, there should have been a certificate of amendment or something of that nature that specifies at least that a vote was taken of the members and it was adopted. I don't really think that it's necessary to put the specific voting percentages in. The alternative would be if you got that amendment approved by a written vote, meaning that you basically just went around from door to door and got proxy forms from everyone. That might be a time when you would record all of the documents themselves, the approvals, with the amendment. Another alternative is if you are needing lender approval because the amendment pertains to something that addresses a lender's interest in the community or in the property, that might be something where the lender's consent is recorded along with it. But generally speaking, nothing wrong with having an amendment recorded via certificate of recording without any specific statement of what actually occurred as to the vote. Okay, Jeff, you're going to have to read them to me now. And you just went on mute.
I moved it to the chat,
Okay.
the last remaining questions. Otherwise, they were going to keep coming in.
Okay. A policy and procedure manual was recorded with our governing documents. What's your thought about the board's obligation to comply with that manual since it's recorded with the governing documents? My thought is that the board is obligated to comply with that manual because it's recorded in the governing documents. The only exception to that would be if something that's in the manual is inherently unreasonable according to a judge and there is an adjudication of the issue. If something is clearly contrary to Florida law, or if it's completely unsupported by the other governing documents because it was adopted by the board, it would not be enforceable. Greg, what's the HOA's role if in any dispute between neighbors? If any, in a dispute between neighbors. Neighbor 1 alleges neighbor 2 made drainage changes while installing a pool that's causing flooding and swamping in neighbor 1's yard. Generally speaking, if the association has an obligation to enforce architectural restrictions, that's something that the board would need to do so that you don't have other people making the same changes and arguing selective enforcement, meaning that you're not enforcing it against this individual neighbor two, but you are trying to enforce it against me. Generally speaking, if it's not something that affects the common areas or more than one lot, I have I won't call it standard, but at least a form that I work up that basically says this is an owner to owner issue. You have the ability under Florida law and our governing documents to enforce this yourself. And if you have a problem with it, go after it. But this is one where if it is causing flooding and swamping in the first neighbor's yard, it might be an obligation of the association to take action, especially if it's something that wasn't authorized that was still changed under your governing documents. And I do have something at 5, so I'm going to rush through the rest of these. I apologize, guys. Kenneth Knapp, is there any guidance in Florida statutes related to coordinating a loan for a condo buildings member so they can afford to pay special assessments? Remember, when we are in an HOA class, there's nothing in the statute regarding HOAs or condos regarding coordinating that loan. You would look at your condo documents, your HOA documents, to see what's required to obtain that loan. There is relief coming for condos, but again, this is something you would want to get into a condo class to learn about. Stephanie Block, if a president resigns, does the vice president automatically go into president? Does the vice president position need to be filled? That vice president would become the temporary president or the interim president, but at your next board meeting, or you can schedule a board meeting specifically to address the issue, what you would do is have that new vote, just like you would at your organizational meeting, to decide who steps into those roles. So it's not an automatic, the vice president becomes the president and everyone else moves up, so to speak. It's, well, we have a vote and we decide who's going to do what. So I think I got through everything. I'm going to reiterate, if anyone has any questions, I truly mean, please send me an email, reach out to me anytime. I'll do my best to get back to you as soon as possible. If we can assist your community, please definitely feel free to reach out to me, because I never complain about new clients that I get the privilege of working with. Thank you, everyone, for sticking around. Thank you, Jeff, for your time. And I'm going to head out. But again, reach out with any questions you might have that I wasn't able to answer today.